Investment Bill, an oral evidence session with the Department officials on the principles of the Justice, Sexual Offences and Trafficking Victims Bill, and further information in respect of the Police Crime Sentencing and Courts Bill, proposed legislative consent motion, and then the two statutory rules on the disclosure of victims of witnesses' information, prescribed bodies, amendment regulations, Northern Ireland 2021, and the criminal justice sentencing licensing conditions, Northern Ireland Amendment Rule 2021, and then written papers on a range of issues. So we have quorum. We will move into public session. Can I just remind members that they are welcome to use mobile devices as long as they're in airplane mode and all devices are muted. This includes members' tablet devices. They can connect to the Assembly Wi-Fi. Also, members are obliged to declare any financial or other relevant interests which might reasonably be thought by others to influence their approach to the matter under consideration, and any member who have interest to declare in relation to today's business should do so or now or when the particular matter arises in the meeting. Are there any interest to declare? Okay. Can we seek agreement with members for the two oral evidence sessions to be reported by Hansard? Great. Thank you. Yes, sorry. Is that okay now?
Yeah, I was just got
here now. Okay. Okay. And I just want to place on record, so that members know, you'll be aware that Sinead Ennis has been appointed as the Deputy Chairperson of the Committee, and I just want to place on record the appreciation of the Committee for the work and dedication of the previous Deputy Chairperson, Linda Dillon, and from the Committee we want to wish Linda well, as she has now gone back to the Policing Board. Agenda item 1, apologies. Rachel and Sinead are joining us by Starleaf. Good to see you. Hope you had a good summer. And Doug and Gemma and Peter are here in person. Still no knowledge from Sinead. Is she planning to join us?
No, I think it's not really. It hasn't gone through the Assembly yet, I don't think.
Right.
I think it's on the order paper for Monday.
Right.
Yeah.
Okay. Right. Okay. And Robin Newton may join us when he was at the education. Okay. Yes, there's an apology. No, Emma has delegated her vote to Gemma. Okay. Thank you. That's understanding order 1156. That brings us to the agenda item 2, the draft minutes of the meeting held on the 8th of July. And those minutes are at pages 5 to 14. And just before we go any further than that, can I just say a word of appreciation to the staff? We have papers today of almost 1,100 pages. And that is a huge amount of material to put together. So a word of appreciation to the staff. But we're at the early stages of the numbers in the packs. We're only at pages 5 to 14. So we have a long way to go. So I hope you'll indulge us here today. So are they content that the minutes are a true reflection of the proceedings of the meeting held on the 8th of July? Agreed?
Great.
Thank you. And I will sign accordingly. That then brings us to agenda item 3, matters arising. Item number 1 is the Department of Justice response on the review of the hate crime legislation in Northern Ireland. And you'll find this at pages 16 to 36 of the meeting pack for the relevant correspondence. At its meeting on the 24th of June 2021, the Committee for Justice considered the Department's initial response to the findings and recommendations in the report of the review of the hate crime legislation in Northern Ireland, published by Judge Desmond Marion in 2020, and agreed to request a range of additional information. Judge Marion subsequently attended the Committee on the 8th of July to discuss his report, following which the Committee agreed to request further information and to schedule an oral evidence session with officials from the newly established Department of Justice Hate Crime Unit on the implementation of the review findings and the recommendations. Advised members that the response from the Department providing the information requested following the meeting on the 24th of June has been received and includes an anticipated timeline for delivery of key milestones for legislative change. The further response will be provided when received, and the Clerk will identify a suitable date for the oral evidence session with officials. Can I just ask members to note the information provided in advance of the further response on the oral evidence session, unless there's any member has any particular question to ask? Okay, thank you. Item 2 is a committee forward work programme from September 2021, and that's at pages 37 to 42. The Department of Justice has written to the committee to request a number of changes to the committee forward work programme for September. These are set out in the clerk's paper and include the removal of one item from the meeting on the 23rd of September and the addition of our written briefing paper for the meeting on the 30th of September. Issues relating to the SL1 in that the Department has asked to remove from the meeting of the 23rd of September have now been resolved, so it can stay on the work programme for that date. So our members agreed that the other changes are acceptable for the September work programme. Agreed?
Agreed.
Thank you. Members, that brings us then to item 4, which is the Damages Return on Investment Bill, consideration of key issues raised in the written and oral evidence session. And this will be with departmental officials, and they are now joining us by Starleaf. Departmental officials are attending this meeting today to discuss the key issues raised in the written and oral evidence received by the committee on the damages return on the investment bill and the answer members' questions. A table setting out the key issues and the department's written response are at pages 53 to 147 of the meeting pack. The issues members may wish to explore during the evidence session are set out in the clerk's paper, which can be found at pages 3 to 6 of the table pack and was circulated to members by email yesterday. Can I remind members that this is an opportunity to get any further information or clarification they need before deciding on whether they are content with the provisions in the bill or wish to discuss any possible amendments. Can I inform members that the further information requested by the committee has been received from the Forum of Injury Lawyers, the Institute of Faculty of Accuracy and the Minister of Health, and can be found at pages 171 to 188 of the meeting pack. So just to ask members to note the additional information unless there is any further clarification required in regards to that. I also seek agreement of the members to write to the Minister of Finance to request the information on the funding of a state-backed indemnity scheme and any Barnett consequential funding as suggested by the Minister of Health. Agreed?
Agreed.
Can I also remind members that the committee also requested the view of the Department of Justice on the potential to make periodical payment orders compulsory, particularly in cases involving government-backed bodies, by bringing forward a policy on this or, if necessary, legislative changes on the basis on which officials and the Minister indicated that the committee could only consider the framework for setting the rate and could not consider the wider implications and impacts of likely changes to the rate on the health service. Just to advise members that the Department has outlined the current position regarding periodical payment orders and indicates that it considers existing legislative provision to be sufficient. It has also set out the basis for this advice to the committee, and the relevant correspondence is at pages 48 to 52 of the meeting pack, and members can discuss these issues further with the departmental officials during the evidence session if necessary. At this stage, can I welcome Lorraine McAlpine, the Deputy Director of the Civil Justice Policy, Jane Maguire, Head of Family Justice Policy Branch, and Martin Moore, Policy Advisor, the Department of Justice, to the meeting, and advise them that the session will be reported by Hansard, and the transcript will be published on the committee's web page. Can I also advise members and officials that you will take, it's my intention to take the clauses in the schedule of the bill in turn as set out in the evidence table, grouping them together where appropriate or whether few issues have been raised. There will then be an opportunity at the end for any other questions or general comments. and officials will be given an opportunity to make brief remarks, including any additional comments that they want to draw to the attention of the committee that has not been covered in the written responses at the start of a particular clause or group of clauses. There will then be an opportunity for members to ask questions and to explore issues before we will move on to the next clause. And that is me endeavouring to try, with the help of yourselves, to do this in an orderly way, and I trust we will be able to progress on that basis. So can I invite Lorraine to make some brief remarks in relation to clauses 1 to 6 of the bill, please. Thank you very much.
Thank you very much, Chair, and for the opportunity to assist the committee's consideration as required this afternoon. We don't have any detailed remarks to make in the clause. We think it might be better to assist the committee as it goes through the bill and to address any questions that might arise. As we've already indicated, it's a fairly technical bill, so I think it's better just to focus on the principles and the sort of overriding objectives of the bill, and just to address any points that members might have following on from previous evidence which we have given.
Okay. Well, can I just start then by asking, in the Department's view, why do most of the organisations representing defendants believe the England and Welsh model is preferable, even though it has indicated that both models are intended to deliver the 100% compensation and the Scottish model is more transparent?
I think, Chair, the defendants might think that, if I was cynical, that there may be more scope to influence the outcome of the England and Wales model because it is less clear and there's a lot more room for the exercise of discretion. They might think there is more opportunity to make representations to the Minister, perhaps to lobby and to bring other pressures to bear. There's no scope for that with the Scottish model, but the Scottish model also still provides for political accountability because the portfolio and the deductions that are to be made are prescribed in the bill and are to be subject to review before any rate is set, and that gives the Minister and the Assembly the necessary oversight and political accountability in terms of the framework, but it removes any opportunity for what might be inappropriate attempts to influence the outcome of setting the rate.
I notice in the paper, the summary of the key issues that we have in front of us in relation to the bill, the comment that comes from the Department, it says that by its nature, a single discount rate cannot ensure 100% compensation for every claimant. The further margin reflects the risk that is inherent in any investment and the sensitivity of the rate to the prescribed parameters. It shifts the balance of risk between under and overcompensation towards defendants and compensators. The latter tend to be corporate organisations who are in a better position to bear that risk than individuals who will be dependent on their damages. Is that a shift in terms of where previously the Department may have been in regards to how it would have viewed the issue of the 100% compensation factor?
No, the Department's objective is still 100% compensation, and that's the objective in England and Wales as well. But we have to recognise that one rate is not going to fit all circumstances because every case is different. So without the application of the further margin, there was a risk that I think 50% of claimants might be undercompensated, but that risk is reduced with the application of the further margin. But as we've said from the start, there's no perfect science to this because it is one rate to be applied to a very wide range of cases. So it isn't going to bring out 100% compensation in every single one of those cases, but that is still the objective. and we think the further margin helps reduce the risk of undercompensation. Unfortunately, in reducing the risk of undercompensation, there is then a risk of overcompensation. So there is still a bit of a balancing exercise in terms of those risks, but it is all against the backdrop of achieving 100% compensation.
And do we have, and maybe this is not possible because it's dependent on the number of claims, but have we tried to give any assessment of what the magnitude of the element of overcompensation might be in terms of the range and the cost?
Can you answer that in terms of the, backline the margin? It would be more than 70% of cases fully compensated or something.
Well, in terms of the further margin, which this question is really asking about, GAD did estimate that applying the margin of 0.5 would shift the risk from a 50-50 risk of undercompensation to roughly 35-65% risk.
Yeah, okay. Peter?
Yeah, I mean, the Chair, I suppose, touched on some of the stuff that I was going to raise, but specifically, obviously, you mentioned, I think, in response to the Chair in relation to why the English and Welsh model, if we're talking about the broad principle, this had not been gone down. I'm trying to remember the exact phrase you talked about. There might be inappropriate lobbying or influence in relation to that. I just wonder if you could maybe expand on where you see the particular fears with that and how you would see those playing out.
I think there's a lot to be said for having the notional portfolio on the face of the legislation and the particular margins to be applied on the face of the legislation, so everybody knows where they stand. Conferring discretion on the Minister means that the Minister may come under some pressure to have a more risky portfolio or a less risky portfolio. There might be arguments that the margins should be higher or lower. And in England and Wales as well, their scheme involves an expert panel. That necessarily adds to the length of the time it takes to fix the rate. Previous experience of expert panels in the context of the statutory discount rate have not been particularly helpful because the experts can't agree. I think our view of this is it's an actuarial exercise because it's about achieving 100% compensation. So there is no real role for political judgment, and therefore as an actuarial exercise it is better carried out by the government actuary in accordance with the parameters set by the Assembly. I think if you move outside that sort of framework, then it would be naive to imagine that the Minister will not receive letters, applications, threatened judicial reviews from insurance companies who may prefer a different shape to the portfolio or different margins to be applied. Whereas if we take it out of that space and put it in the legislative space and in the hands of the government actuary, that sort of risk and challenge is removed.
Okay, I mean, I suppose where the balance is to be struck is between where there is that both certainty and indeed trying to take some level of pressures out of that. But there does seem to be that, for instance, in terms of the level of circumscribing of the government actuary, because obviously there's reference, for instance, to then the actuary can draw on expert advice, but there's no, it's not circumscribed as to where that comes from. And to some extent then, are we tying the hands of the Minister, maybe rightly so, but then leaving the government actuary without really sort of a clear-cut position of what they can get? And similarly, I suppose, if we're saying that there's no flexibility for the Minister, but there is, I think, flexibility at times can be if there's a particular sort of court decision to be taken, that the courts will have a level of flexibility. So I suppose we're just trying to square off in my mind what the appropriate balance is of levels of flexibility as opposed to prescription.
I'm not sure that the court really, I mean, once the discount rate is fixed, I'm not sure that the court really does have a lot of flexibility. I know clause C1(2) allows the court to take a different rate into account if it shows that it's more appropriate. But there's case law from the Court of Appeal in England and Wales that very, very heavily circumscribes that power, so that it really only is possible for the court to apply a different rate where the party to the proceedings could show that the particular circumstances of their particular case wasn't considered or wasn't dealt with in the context of setting the statutory discount rate. And I actually can't even imagine what those sorts of circumstances would be. I don't think a court has ever in Northern Ireland set a different rate from the one prescribed. So
yeah, I suppose from that point of view, is it just to cover some unforeseen case? I mean, I'm just wondering a little bit the logic of saying, for instance, a court has a power to do something, but we can't envisage it ever doing it. It's never happened in the past. It does seem to kind of leave a door open, which then seems unlikely to be gone through. And I wonder whether there's any, is there a particular rationale for saying that we'd want to leave that ajar for some reason?
Well, that provision has always, it has been in the Damages Act 1996, so we're just retaining it. I mean, we couldn't rule out that there may be some very particular sort of case where the court thinks, well, yes, the statutory discount rate really shouldn't pertain here. But I mean, like you say, I couldn't describe that case. It may be one of those things, well, you know it when you see it. And I mean, the power doesn't do any harm if it's sitting there and the court can't exercise it. Well, so be it. But if a case came along where a court would have found the power useful, then it would be a shame not to have it.
No, I mean, I just, like, put it this way, I understand perhaps having some sort of fallback position of some description. I would just say, like, in terms of as a convincing argument, effectively the argument saying this has always been in there, I think I would like to see probably stronger rationale than that. I'm not saying that, but thank you, Chair.
Okay. Sinead? Okay. Sinead, have you a question?
Thank you, Chair. Can you hear me?
Yes, we can hear you now, Sinead. Yes.
Thank you. Yes, Chair, I appreciate that. Just at the outset, the parameters in which we're actually considering this, the committee have been clearly told that we must not concern ourselves with the consequences or the costs, but we must aim at the target of 100%, which I understand. But I also understand that when the proposal was brought to the Scottish Government, it did have with it estimates on what the financial cost to the NHS would be. And also I'd like to ask the question, on the 31st of May, the interim rate was set, but I'm wondering, is that still considered an interim rate? And I ask that specifically in a Northern Ireland context, in terms of if politics did become unstable, would the department be considering to revisit that rate, or would they consider that to be something that they would carry on indefinitely? Because no doubt the markets are looking on to see what the next step for them is. And then moving on to the detail, I suppose, of the actual bill, where I would like to be, in terms of then, there's two pieces in there. There are two discounts, and it's been suggested to us that that's double accounting, and that we're looking at the same discount twice. And I'd like to know what the department thinks of that charge. Is it double accounting? And if not, why not? Thank you. Thank you, Chair.
Well, maybe if I take the question about the what's described as the interim rate, first of all, I think that describing it as an interim rate is a bit of a misnomer, because it's only interim until it's replaced. I mean, it is actually the rate, and it will remain in place until such times as a new rate is set. The department has no power to fix a rate at the minute, except under the Wells and Wells criteria, which is the one that at the time led to a rate of minus 1.75%. I suspect if we were to fix another rate under Wells and Wells, then the rate would go even lower. So the rate will and we will be under a duty to keep it under review under Wells and Wells if the bill isn't enacted. So there's nothing we can do about the minus 1.75% except keep it under review, but that is in the context of a Wales and Wales framework, where it might go down to, I mean, I don't know, it might go down to -2% if we were to look at it again. But I mean, the difficulties with Wales and Wales is why the department was so keen to have the new framework put in place as soon as possible. And on the question about the two discounts and is it double counting, there is a discount specifically for the cost of management advice and tax, and that's 0.75, and then another discount, the 0.5 further margin discount, which in Scotland they described as sort of margin of prudence, and that really is to take into account the fact that this isn't an exact science, and in the balance between under and over compensation, I suppose we're more concerned that personal injury claimants shouldn't be undercompensated. I think GAD, there was an argument that the discount for 0.75 might actually should have been higher, that the cost of management and advice is actually more than that. So to some extent in fixing that deduction at 0.75, some regard was had to the fact that there is also a further deduction of the further margin of 0.5%. And on the cost issue, sorry, that was actually your first question. I'm taking them in reverse order. I think that the cost of this for the Department of Health is really a matter for the Department of Health. We know that I think in May last year there was something like 138 high value cases, and I expect that Department of Health officials have put a cost on that, but our the risk here is that if the department gathers much information on the cost of the new scheme or the discount rate, it looks very much like we are taking matters into account that we shouldn't take into account, because if the law requires 100% compensation, then why would we gather information about the cost of that? I mean, in the reply to the Justice Committee, we set out, I couldn't put it better than Ms Justice Irvine in the Irish Court of Appeal, where she explained that the economic cost to defendants or the insurance industry or public finances is a consequence of the loss which has been sustained by a plaintiff who was just the unwitting victim of the defendant's wrongdoing.
Thank you. And if I may, Chair, come back on that. I accept your point, you know, the plaintiff, the cost is the cost. But I just think from a departmental perspective, the fact that we're working on legislation that has the potential to have a very significant cost to not just the Department of Health. I suppose this could have an effect across all departments, but and also the private sector. But is there, are you telling me then that there hasn't been, for fear of being seen to be motivated by the cost, have the department absolutely carried out no work on the effect of this? Or in which case then the Department of Health, I suppose it's fair to assume, will not have made any representations to Treasury to say this may be this significant that we would need extra help here. I can appreciate we as a committee are being told to focus on the target, but I suppose what I am seeking is some type of reassurance that somebody somewhere is actually looking at the bigger picture and saying this is significant and that the Department of Finance are on the ball here. Thank you.
Let me maybe try and help there. The Department of Finance are on the ball, and I think they have put a paper into Treasury highlighting this. I should also say, though, that the cost of this legislation is likely to be less, possibly significantly less, than the cost of the rate which we were obliged to set under Wales and Wales. So if anything, the bill will actually represent a saving compared to the rate, the minus 1.7 rate, which currently applies under Wells and Wells. But we have been engaging with the Department of Finance, and they have put a paper to Treasury. So it's not that wider government isn't aware of the cost implications of this.
I understand the Department of Finance officials have done some modelling on the impact of various rates, but that's not something that we're exposed to in terms of the detail.
They're the ones who are engaging with the Department of Health and then with Treasury.
Thank you, Chair.
Thank you, Sinead. And can I just maybe give a wee bit of advice or maybe guidance to members? If we can try and stay within and I know it's always a challenge for us, the structure of looking at clauses 1 to 6, and now we're going to go and look at Schedule C1, which is paragraphs 1 to 6 of the bill.
Clauses 1 to 6.
Yes, and just is there any other questions that we have in terms of clauses 1 to 6 of the bill? Before Rachel?
No, it's okay, Chair. Mine would be in Schedule 1 and beyond.
Okay, thank you. Okay, just maybe one more query in relation to clause 1 to 6. And I suppose maybe to the degree it has been answered in that, does the Department believe that the proposed framework provides the sufficient flexibility to change the portfolio or adjustments quickly, if necessary, given that secondary legislation will be required to do so?
Well, I suppose the secondary legislation is also the bit that gives the Assembly its oversight of this and provides the framework. There is to be a review of the portfolio before any new rate is set, and the first review after the initial review will be in July 2024, so that's probably going to be maybe in a couple of years' time after the first rate is set. So yes, we do think it is sufficiently flexible.
Okay.
There's also the provision for an extra review to take place within the 5-year review period if circumstances arise that would merit that. So there's flexibility there, and that we're not stuck rigidly to every 5 years.
Okay, thank you. That'll bring us into the Schedule C1 of the bill, which is setting the rate for the section C1. I suppose maybe what I would ask there is, how do the proposed review periods align with the England and Wales cycle?
They align with the Scottish cycle.
Okay, and not with the England and Wales one?
No, the Scottish one, yeah.
England and Wales rate was set at a different time to
yes, right,
in
okay.
Scotland, so although they do have a similar cycle of regular reviews.
We think there could be efficiencies in aligning with Scotland because the model is so similar. It's for GAD to do their exercise or efficiencies for them, so there could be cost efficiencies for the department in doing that, as well as for the government actuary.
Okay. Any questions members have on that? Just please indicate at this screen here. I can't see.
I'll let you know.
Just in case there's a member on. Okay, if there's no questions on that, that then brings us to Schedule C1, paragraphs 7 to 9. And I suppose we would ask there, what is the effect of adopting the 43-year investment period rather than the 30-year investment period on the discount rate?
Well, the government actuary has advised that in practice the difference between an assumed investment period of 30 years and one of 43 years is likely to make only a very small difference of 0.1 or 0.2% in the rate calculation if everything else was equal. So since the discount rate is rounded to the nearest 0.25%, the material effect in the rate would be either nil or 0.25. I'm giving a sort of an example of that. So say for argument's sake, an investment period of 30 years produced a return of 1.9%, and an investment period of 43 years produced a return of 2.1%. Both figures would be rounded to 2%, so there would be no difference. If, on the other hand, a 30-year investment produced a return of 2% and a 43-year investment of 2.2%, then the 30-year figure would remain at 2%, but the 43-year figure would be rounded to 2.25%. I mean, I'm making those numbers up, obviously. If you applied a difference of 0.25%, then again, a sort of completely random example of a 30-year-old man with a £50,000 a year annual requirement, a rate of minus 0.25% would equate to damages of 2.9 million, and a rate of 0% would be 2.773 million. So that's an illustration of how it might work out, but you know, it's hard to know outside. That's just one example. Applying it to any individual case, we can't do that in this forum.
I think the question really is, rather than what is the outcome of a 30-year or a 43-year period, is 43 years a reasonable period to assume? So you should be looking at it from that point of view rather than what the outcome would be of applying it.
And it is evidence-based, which is the reason that we voted for that, as opposed to the 30-year period under the Scottish legislation.
Does the Department intend to gather the data on the average investment period for claimants in Northern Ireland, so that would inform any further consideration, or whether there was any change that was required for the assumed period of the investment?
I think data gathering is very difficult because these are private individuals who will invest their money, or in some cases maybe not invest their money in whatever way they think fit. I think it could be quite intrusive for the department to say that you've suffered a serious injury, you've got a large amount of compensation either from an insurance company or from the health service, and from here on in we want you to tell us how you invest that and over what period. It would just be a huge exercise, and I'm not actually quite sure what we might do with that information. I mean, it's really about, I suppose, life expectancy of individuals. So you would even be trying to run it, gathering the data now to see whether in 43 years' time if that person was still relying on the investment or not. Yeah. It would be a huge exercise. We have no plans to undertake it, and I'm not really quite sure about the value of it, certainly relative to the invasiveness of it for individuals and the resource that would be required to gather it.
Okay, thank you. Any other questions member have on those paragraphs of C1, 7 to 9? If not, then we'll move to paragraphs 10 and 11. And I think in some degree some of those have been asked, but can I just maybe ask, what level of risk of the overcompensation does the department believe is acceptable? Because it's one thing to have a sense of that's what it may likely be. However, what is the department actually believe is an acceptable overcompensation amount?
Well, I suppose the answer is no level of overcompensation is acceptable, and the same that no level of undercompensation is acceptable. But we need to be realistic about what is achievable. And I mean, both in Scotland and in England and Wales, the margin of 0.5% was applied in order to reduce the risk of undercompensation to, I think, 35%. That still means that 35% of people will be undercompensated, and that others will either be fully compensated and a few may overcompensated. think the risk of undercompensation brings in the question of periodical payment orders. If a claimant was so concerned about undercompensation, then they could consider that avenue. I mean, under or overcompensation can apply in any case if a claimant died shortly after receiving the lump sum settlement, or if a claimant long outlives his life expectancy, then there's going to be questions of under and overcompensation. But we think the 0.5% margin gives us a sort of reasonable balance.
Yeah. In terms of, which is another issue has been raised with us, and it's really to try and get a sense of what the department's view is on the proposal to remove the standard adjustment and to allow defendants to pay for cost of future financial advice as a separate head of claim through the negotiation or award at the time of settlement.
I suppose it's up to claimants and defendants to settle their cases on the best terms that they can, and that's up to them in consultation with their legal advisors.
I think that point sort of goes to the point about why we have a single discount rate in the first place that applies to all cases. And the purpose of it is to reduce the work and the cost and the time of parties to negotiate between themselves very complicated calculations which are going to cause delay and increase costs for claimants. So the discount rate removes that from the whole negotiation process, and I suppose the same argument would apply here. If you took out that standard adjustment from the legislation, then you're adding that into the negotiation that would have to be done between parties.
Any other members, any other questions? Okay, can we move then on to paragraphs 12 to 15 of Schedule 1? And some of this has been raised, but I suppose what I would ask is, what's the difference between the notional portfolio and the bill and the one that's used in England and Wales?
Well, the one that was used in England and Wales, but we don't have the detail of that in front of us. We think it may have been slightly more risky, but in any event, there's no assurance at all that that would be the same portfolio that would be used in England and Wales next time round.
Yeah.
I mean, that's part of the problem with the England and Wales portfolio not being set down anywhere. It's you don't know what it would be going forward.
If that approach was adopted here, I mean, you wouldn't know what decisions a Minister of Justice here would decide in terms of the composition of the portfolio. That could be different to the portfolio that the Lord Chancellor in the last review in England and Wales decided upon.
And given the longer investment period, I know we're going back to that issue and we're dealing with it, so it's the 43 years and the 0.5%. Is the 0.5% further margin necessary then, in terms if you take it over the 43 years?
Well, yes, because if you don't apply it, you're still only 50-50 of people getting, their full compensation. I mean, I think it is instructive, even though they've approached this differently. Both England and Wales and Scotland have both applied a 0.5% margin. Who knows, the next time England runs this exercise, they may apply a lower or a higher margin. But I think there is recognition within this, because it's not an exact science, and because the claimants are most at risk. And ultimately, if their settlement doesn't meet their needs for their lifetime, then they will fall back in the health and social care system. That it is appropriate to try and manage this so that there are fewer people undercompensated than overcompensated, although recognising that even in doing that, you run a risk of overcompensating as well.
And unless there's any other members have any questions related to these paragraphs, one of the things that we noticed was that when the government actually reviewed the notional portfolio for the bill, was account taken on the longer investment period being adopted, and if so, were any adjustments made to the portfolio?
Well, we did ask the government actually whether using a 43-year period would change GAD's opinion of the content of the notional portfolio, and the answer was that they were still satisfied that it was a reasonable portfolio to use, whether or not there was a 43-year or 30-year investment period.
Okay. Thank you. Any member, any questions or contact to those in Starleaf, as in case Sinead or... No, there's no hands up. Okay. Schedule then C1 paragraph 16 to 18 of the bill, and in terms of that part of the bill, is it the intention of the department to hold a full public consultation regarding whether the notional portfolio remains suitable to enable all interested stakeholders to submit views when reviewing it?
Sorry, Chair, could you repeat that? I didn't quite hear.
Is it the intention of the department to hold a full public consultation regarding whether the notional portfolio remains suitable to enable all interested stakeholders to submit views when reviewing it?
We wouldn't certainly not doing that before the bill is enacted, but when the next review is required in July 2024, I imagine that I can't bind a future department or a future minister, but I imagine we certainly want to consult GAD, and they may want to take other views as well. But I really, can't speak for what a future minister might do.
Okay. Any other questions members have on that section? If not, move to paragraphs 19 to 34. I suppose, given the provision has been made for this in terms of paragraphs 19 to 34, does the department intend to consider a dual rate approach in the near future?
Well, we've no plans to set a dual rate. I mean, we're just trying to get the new framework established, and that is the immediate priority. That's not to say that at some point in the future we wouldn't want to consult on whether a dual rate was a better model. I mean, we're just not doing it this time round when the priority is getting the new framework in place and to replace Wells and Wells.
Okay. Members, any other questions in relation to the bill? I just want to make sure that I've got... Is anybody online? No? Rachel, have you questions? I can't see the screen, is it? Hello, Rachel, are you there?
Thanks, Chair. Sorry, just waiting to get in to the spotlight there. Thank you very much, Pat. No, you've answered a lot of questions on that one. I just want to pick up on the interim rate that was struck in May, and I know that there was some questions and some concerns raised about that at the time, but has there been any issues raised with the department with this rate being struck since then? Has there been any settling of cases? And if there's been any analysis done on any cases being settled since the minus 1.75 rate was introduced?
I would be surprised if there were many cases settled. I mean, our impression, I think including from the Chief Justice's correspondence or evidence to the committee, that cases are being delayed. I mean, why would a defendant settle at a minus 1.75 rate when there's an expectation that there will be a different rate set under this bill? The department wouldn't have knowledge of cases settling or not settling because they're really between private parties. So we don't know how many cases would have been close to settling which have been delayed, or we've no insight into cases which are settling. We have received, I think, at least one letter about the impact which the minus 1.75% rate is having or will have if it continues.
Well, thank you. Just I know there was a lot of concern at the time, so it's just interesting to know what's happened since then. There was a number of submissions, and we took a bit of evidence during the last couple of months on periodical payment orders. And I'm just wondering if you have any information on why you think, or any analysis of why you think the number of PPOs that are entered into are low?
No, I think the evidence to the committee was interesting on that issue. I mean, defendants and claimants both seem to have their own reasons, and in some cases
they both seem to blame the other side.
They both seem to attribute the difficulty to the other side. Yeah. So, I mean, you can maybe see the attractiveness of the insurance companies of getting the thing off their books, and for claimants to feel, well, they've got charge of their future in this lump sum payment. As we pointed out in our correspondence, it is already possible for a court to impose a periodical payment order without the agreement of the parties, but I don't know that happens very often. I think where there is an injury at birth case, there may be more cases of periodical payments, and you may get sort of mixed orders of periodical payments combined with lump sums.
Okay, thank you, Chair, and thank you again for your attendance today.
Thanks, Rich. Gemma.
Thank you, Chair. And I'm assuming we've moved on to other issues now.
Sorry?
Have we moved on to other issues now? Or are we
yes.
Grand. Sorry, I didn't want to mix up the whole process.
No.
No, just one question. Given the huge concerns around the current interim rate and, that it's the lowest on these islands, and given the anticipated new rate, does the department, do you have any idea of how much higher the new rate will be? And have you done any work to assess the impact of this rate?
We have no way of knowing what the new rate will be. It'll be a matter of if the bill is enacted, then the government actuary will run the portfolio and they will tell us what the rate is. We've given the government actuary under the bill is 90 days to do that. So that's the point at which we will know what the rate's going to be. There's no way that the department would be able to try and work it out ourselves. I think that would be an inadvisable approach when somebody wouldn't have the expertise for it, and it would be odd to ask GAD to do it now, since they're going to have to do it when the bill is enacted, and in fact in 90 days time the rate could even be different from the rate if it was set today. So I would expect that the rate will go up from minus 1.75% purely on the basis that is calculation on the assumption of investment solely in index-linked gilts, where the portfolio allows for investments in other investment products, which should provide a better rate of return than index-linked gilts. So I think inevitably the rate will go up, but we are just not in a position to say by how much.
I think the only thing we could say with certainty is that a rate set under the framework in this bill would be higher than a rate set under the existing framework at the same time. But the time that it's set does play a part in determining what the rate is.
Okay, thank you. Thanks, Chair.
Thanks, Jim. And on that, are we saying then that the regulatory impact assessment didn't give us any indication in terms of the cost?
Yeah, the regulatory impact section was only, we don't have the data available to be able to work out the cost, even if we knew what the rate was. Right. So there are a number of factors that meant that we weren't able to work out a cost, not least that we wouldn't know what the rate would be. All the regulatory impact section was able to do was determine the cost under one framework relative to another.
And in conclusion, there's been an issue that we have noticed or has been raised, and that is that the damages for pain and suffering are higher in Northern Ireland than in other UK jurisdictions. And would it be the intention of the Department to consider any legislative reforms similar to those that took place in England and Wales and in the Republic that were designed to lower claim costs?
Well, that's outside the immediate scope of this bill, Chairman, but we'll help as best we can. General damages for pain and suffering in Northern Ireland are higher than in England and Wales because for longer in this jurisdiction the damages were set by juries, and juries were maybe more generous in deciding what the damages should be. And even when we abolished juries in civil cases, the courts tended to continue to apply really the precedent rate of damages which have been set by juries. There is a book called the Green Book on Damages, which indicates, I think it's published by the Judicial Studies Board, which indicates broadly what you would get for any particular type of injury, and that's a matter for the judge. In the case, I'm not quite, I mean, it'd be difficult to legislate to cover the damages in every single set of circumstances. I know in England and Wales they have the Partial Injuries Board. That might not be the exact title of it, but it is a forum for the resolution of partial injury claims, and claims in Ireland have to be submitted through that board before they can go to court. I don't think that the parties are obliged to accept the outcome of that process. So when it works, it's probably very good, but if it doesn't work, then it causes delay, because after going through the board, then you still, and if you don't accept the outcome, then you still have to go to court. I'm not sure I'm in a position to say an awful lot more about the level of general damages in Northern Ireland at the minute, except to say it is a legacy of juries fixing those damages in this jurisdiction for longer than in other jurisdictions.
Thank you. And finally, just in terms of just for our own purposes in relation to the progress of this, does the Department intend to bring forward any amendments to the bill at the consideration stage? No. No. Okay.
No.
Okay. That makes that very simple. Thank you. Well, can I just then, if there are no other questions, maybe just check to make sure that nobody has their hand up, or no, thank you. Can I then just thank the officials for their attendance today, and obviously we will see the further progress of this bill at consideration stage. So thank you again for your help. Thank you for the information that you have previously provided to us. It is much appreciated, and thank you for your attendance today. Thank you very much.
Thank you very much.
Thank you. Okay, maybe just a couple of things to tidy up in relation to following on from that. Maybe can we just advise members that the committee will undertake informal deliberations on the provisions of the bill at its meeting on the 23rd of September, with an aim of establishing whether members are content with each clause and the schedule as drafted, or wish to consider possible amendments. So that's just to inform members. I do think, and Christian, can you just advise in relation to this? I would have a concern. The Health Minister has set out a concern in terms of the implications of this. On the basis of what we have heard today, it's quite clear that both the Minister and the Department are not of a view to be in a similar place. How do we, because we need to be clear in our minds that the concerns that have been, and I think probably could be said of other departments, not only the Health Minister, obviously, I would assume takes a considerable degree of these claims, but there will be other departments that this could impinge on. Are we satisfied that it is just enough for the department and the Minister to be not dismissive? They certainly are not saying that they're going to do anything to, that where they believe they are is the place to be, and that the fears that are being expressed by the Health Minister are not something which is of real concern at this stage? Should we write? Well, we have to write back to the Health Minister and try and give some sense of this discussion that there was today and the response that we've had from the department. Yes?
Yes, I mean, if the committee wants to write back to the Health Minister, yeah, you can. I think the Health Minister has made the point that he's keen for this legislation to get through as quickly as possible, because the current rate is definitely going to be more penal than the rate that would potentially be set under this bill. So in some respects, parameters have moved by setting the new rate. It has actually caused more of an issue for them. I think if you want to go back to the Health Minister and advise them that you are looking at it, I think the issue for the committee when they're looking at this bill is to assess whether, with all the information you've got, that the framework that's in the bill is going to be as close as possible to achieving 100%, or whether you feel there are some issues there that are putting it too far one way or the other. The Health Minister himself has, I mean, he is supportive of the 100% compensation, but I also think in the committee report that you can highlight the difficulties that it will cause and is causing for the Health Department. I mean, the committee has already agreed to write to the Finance Minister to try and ascertain the situation regarding Treasury funding and for any relating to any possible indemnity scheme for GPs, for example, and whether there was Barnett consequentials already provided to here. So I think there are certain things that you can do. I think the difficulty is if you're assessing or if you're wanting to achieve the 100% compensation, there's certain things that you may want to know the implications of, but whether those can be, will change your decision on how you set the rate is a different issue.
I think, I mean, I agree with that. I mean, I think the issue though, I suppose, is I don't think anybody's looking to be obstructive in relation to this, but I think we just need to make sure that anything that is going on, that we do so at least with the eyes open, particularly financially. And I know, I appreciate, probably Christine had highlighted, I think from the point of view of what was being sought, the information is being sought from DOF, which I think is useful enough as well. I was going to suggest that, but that seems to be already in track. I'm just conscious, I think there is a good argument which essentially says you do the 100%, you accept that as a principle. I'm just conscious maybe that none of us want to be in a couple of years' time in front of a PAC or an audit, and they say, well, why is this cost such and such more than anticipated? And we say, well, we didn't have a clue how much it was going. You know, I think the more information we get, I still think it's the better. But even if I think accepting that, I think there seems to be a broad movement of consensus of principle in terms of this. Yeah.
Okay. If there's any other questions in relation to that, just really for information as well, that all the documentation or the response department response to the summary of the evidence table and the other correspondence will be added to the electronic bill folder on the committee web pages, so that will be there for members' information. Thank you. Members, that brings us then to item 5 of today's agenda, which is the Justice, Sexual Offences and Trafficking Victims Bill Principles of the Bill oral evidence session with departmental officials. And just to remind members that the bill was approved by the Executive on the 24th of June and subsequently introduced to the Assembly by the Minister of Justice on the 5th of July. And given the time available for the bill to complete its passage to the Assembly before the end of the mandate, it has a very limited time in terms of that progress. And at its meeting on the 8th of July, the committee agreed to issue its call for written evidence following the introduction of the bill, rather than waiting until the second stage is completed and the committee stage has commenced. The call for evidence issued in July. The closing date for receipt of written submissions is Friday the 24th. Departmental officials are attending the meeting today to provide an overview of the bill, and the relevant pages are in relation to page 190 to 270 of the meeting pack. And can I welcome, I hope, into the... Yes, here we are. We'll just give... Peter. I welcome Peter Grummick, the Deputy Director of Criminal Justice Policy and Legislation, and Lorraine Ferguson, the Head of Criminal Policy Unit at the Department of Justice. And there's no, you don't have two other colleagues?
We're waiting for them to join.
Are they going to join
Starleaf.
by Starleaf?
Yeah.
And they are Ronnie Pedlow and Alison Redmond, correct?
Yes.
That's correct, yes.
Okay, Brian, you're very welcome, and thank you for your and Lorraine's attendance at the committee today, and we'll just ask you to give us an overview and a presentation to the members, and then there will be some questions, I have no doubt. Thank you.
Right, Mr. Chairman. Thank you very much for your warm welcome and giving us the opportunity to brief you today on the principles of the Justice, Sexual Offences and Trafficking Victims Bill, which passed its first stage in the Assembly on Monday the 5th of July. I will give a brief overview of the content and principles of the bill, and then myself and my colleagues will be very happy to answer any questions you have at this stage. Obviously, I appreciate this will be part of a long process over the coming months. The bill itself is a significantly smaller bill than originally intended. As you recall, we were initially going to put out a much broader miscellaneous provisions bill, but ultimately that was slimmed down, and the current bill now comprises only 22 clauses spread over 4 parts. The bill has 2 key principles. Firstly, to enhance public safety by implementing certain elements of the report of the Gillen Review of serious sexual offence cases, and also a review of the law on child sexual exploitation and sexual offences against children. The other principle underpinning the bill is to improve services for victims of trafficking and exploitation. Turning to Part 1, in Chapter 1 of the bill, the bill is primarily concerned with the creation of new sexual offences and penalties, with the first provisions capturing the highly intrusive behaviours often known as upskirting and downblousing. A person found guilty of either offence under these provisions will be liable for a sentence or imprisonment, a sentence of imprisonment of up to 6 months, or a fine not exceeding the statutory maximum of £5,000, or both, on summary conviction in the Magistrates' Court. For the more serious cases, a conviction on indictment in the Crown Court will attract a penalty of up to 2 years' imprisonment. The next provision in this part of the bill, next provisions are designed to better protect children from child sexual exploitation. They create 4 new offences: deal with an adult pretending to be a child or masquerading as a child, and making a communication with a view to sexually grooming a child under 16. The 4 offences are really very much a belt and braces approach. They seek to cover all possible angles: communicating with an individual, communicating with a group, communicating with a view to grooming a particular child, and communicating with a view to grooming any child in the group under 16. Importantly, they are not limited to online behaviour. The penalty for each of these new offences is a sentence of imprisonment of up to 6 months, or a fine not exceeding £5,000, or both, on summary conviction, and a sentence of imprisonment of up to 2 years for a conviction on indictment. The remaining provisions in Chapter 1 of Part 1, the remaining provisions in Chapter 1 of Part 1 amend provisions of the Sexual Offences Northern Ireland Order 2008. They include removing and replacing existing references to child prostitution and child pornography. Such terminology is now outdated and may be taken as implying that children are in some way responsible for or willing participants in their own abuse. The Department believes that amending legislative references will go some way to helping raise awareness of the status of children as victims of exploitation rather than as willing participants or being complicit in the abuse perpetrated by others. We're also widening the scope of the definition of images relevant to specific offences within the 2008 order to include live streaming. This will ensure that the law is in keeping with developments in modern technology. This helps also to avoid any ambiguity in terms of the interpretation of what constitutes an offence. The bill also makes a minor amendment to bring Article 22A offences covering sexual communication with a child into scope of extraterritorial arrangements to provide further protection to children travelling outside of this jurisdiction. This simply corrects an omission in the current law where this provision should have been previously included. Finally, for this chapter, a minor adjustment is also being made to the current Article 64A offence of paying for sexual services of a person. This clarifies the elements which constitute an offence to avoid any ambiguity in its interpretation. Moving on to Chapter 2, Part 1 of the bill, this brings forward provisions to implement 4 recommendations in Sir John Gillen's report into the law and procedures in serious sexual offences in Northern Ireland. The provisions will, firstly, extend the current lifelong anonymity of the victim of a sexual offence and provide for their continued anonymity for 25 years after their death. Secondly, provide for the anonymity of the suspect in the sexual offences case up to the point of charge. Where a suspect is not subsequently charged, then this anonymity will be continued and protect them during their lifetime and again for 25 years after their death. Thirdly, it increases the penalty for breach of an anonymity from the current penalty, which is a fine of £5,000 on summary conviction, to a sentence of up to 6 months imprisonment or a fine of £5,000 or both. And finally, this part excludes the public from hearings of serious sexual offences cases. Only the complainant, the accused, persons directly involved in the proceedings, a witness while giving evidence, any person required to assist a witness, jury members and bona fide members of the press will be allowed to remain in the court during the hearing of a serious sexual offence. The court will retain, of course, discretion to permit any other person to remain in the court where it considers that this is in the interest of justice. Turning to Part 2, which covers trafficking and exploitation. This deals with, as I say, trafficking and exploitation. This helps to avoid any ambiguity. Sorry, let's turn the pages and undo. This provision extends statutory assistance and support to adult potential victims of slavery, servitude, and forced or compulsory labour where there is no element of trafficking. The provisions of assistance and support to such potential victims has been in place in Northern Ireland since March 2016, but it is not a statutory requirement. Placing the arrangements onto a statutory footing provides reassurance to victims that the Department is committed to providing support and assistance to those who have been subject to slavery, servitude, and forced or compulsive labour. Compulsory labour. The provisions in this part of the bill also amend an existing requirement to publish a modern slavery and human trafficking strategy, changing the timing from at least once every year to at least once every 3 years. By their nature, strategies set out longer-term objectives, with actions or implementation plans recording milestones within each financial year. Bringing forward an amendment to enable the strategy to be published at least once every 3 years will allow the Department and its partners to focus better on the implementation of actions underpinning the strategic goals and to monitor progress of relevant contributors. As some objectives span more than 1 year, this will also have a positive impact on performance management. Moving to Part 3 of the bill, this comprises 2 relatively minor clauses. These make adjustments to existing legislation to strengthen the effectiveness of sexual offences prevention orders, that's SOPOs, and violent offences prevention orders, VOPOs. The SOPO provision amends Schedule 5 of the Sexual Offences Act 2003 to include the offence of abduction of children in care. That's under Article 68 of the Children's Northern Ireland Order 1995, in the list of the specified offences for which a SOPO can be applied for. This would mean a SOPO could be applied for in respect to persons who present a risk of serious sexual harm, while they have been convicted of the offence of abduction of a child in care. The VOPA provision amends the Justice Act Northern Ireland 2015 to remove the statutory 6-month time limit within which a civil complaint must normally be made to court. This will ensure that the behaviour of an offender evidenced more than 6 months previous to an application being made for a VOPO can still be considered by the court. This concludes my remarks covering the substantive policy content of the bill at introduction. I would like to take the opportunity also to provide members with a short overview of the small number of amendments that the Department is currently developing for inclusion in the bill, which have previously been advised to the Executive, and I think the Committee in a number of cases has expressed previous interest in these amendments. Our first amendment is the addition to the Gillen provisions in the bill, relating to the exclusion of the public from hearings of serious sexual offences. This will extend those provisions to include the Court of Appeal as a setting where the public can be excluded from appeal hearings against conviction or sentence in serious sexual offences. That, in essence, actually means, in fact, that exclusion is both in the court when the case is first heard, but also if there's an appeal, that would also be covered by a similar provision. There are also 3 planned amendments covering new policy content, the first of which relates to what is known as the rough sex defence. Consent to serious harm for sexual gratification has been raised in trials as a defence to serious harm, murder or manslaughter a number of times in recent years, and is currently addressed by the common law. The Department intends to set in legislation the existing common law position that a person cannot lawfully consent to their serious harm for the purpose of sexual gratification. The amendment will give effect to a ministerial desire to address perceived issues of clarity and consistency regarding the application of the existing common law position. The second new policy amendment relates to what is commonly referred to as revenge pornography. The provision is intended to make threats to disclose private sexual photographs and films with the intent to cause distress and offence, alongside existing offence provisions related to the actual disclosure of such material. In other words, it's not just actually disclosing, but also the threat to disclose itself will become a criminal offence. The final amendment is to change the existing legislation covering an abuse of position of trust of a child, contained within Articles 23 to 31 of the Sexual Offences Northern Ireland Order 2008. The amendment will provide greater protection to young people who are in the care of adults in certain non-statutory environments. As I have advised the committee previously, the Department originally planned to develop this proposal for introduction in the next mandate. However, responding to recent developments in other jurisdictions and an increasing number of lobbying requests for the law in Northern Ireland to be changed, the Department and the Minister now consider that this important change should be made sooner rather than later. In bringing this proposal forward, the Department has been working closely with the NSPCC to gauge the wider views regarding the scope and the content of this amendment. This includes holding a joint virtual workshop with NSPCC at the end of May, which involved representatives from a number of key stakeholders, both statutory and community stakeholders. As a result of that engagement, and having examined the experience of other jurisdictions, the Department intends to extend the current provisions for abuse of position of trust of the child. The extension will cover the abuse of positions of trust held in sports and faith settings, with a delegated power to enable extension of those settings at a future stage, should this be considered necessary. I think that brings me to the end pretty well of my presentation, Chair. I'm sorry if that's taken a bit longer than we'd expected, but for a small bill, there's quite a lot in it. I thank you very much again for the opportunity to brief you today on the principles of this important bill. I hope you found this of benefit. Myself and my team are very happy to answer any questions you have at this point, and we look forward to working constructively with the committee in the coming months as this bill progresses through the Assembly. Thank you very much.
Thank you very much, and thank you for those introductory remarks. What are the operational concerns that have prompted the amendments to the Sexual and Violence Offences Protection Orders?
The SOPAs and the VOPAs.
Yeah.
SOPO, if I could just answer that, Chair. Abduction of a child in care isn't currently on the specified offence list for the SOPO, and there were difficulties with some of the operation elements by police where there was risk of serious harm of a particular perpetrator, and if they could have availed of a SOPO had the SOPO been in the specified list. It wasn't included in the original list because at that time the 2003 Act provisions were translated across to the 2008 order, and we have no particular policy objection to it being included if it improves the effectiveness of the order.
Okay. There's been some concern raised, and apologies because this is a read over back to the Human Trafficking and Exploitational Bill. And at that stage, there seemed to be an understanding that there would be no further amendments in relation to that. Now we have an amendment to Article 64 of that particular piece of legislation. Just what's the rationale? Because we seem to be getting into almost a debate between legal interpretation and legal counsel that while it'll be accepted the proposed drafting is slightly tighter than the current wording, but when people then start to unpick it, they believe that it doesn't fulfil what the original intentions was.
That's correct, Chair, and the Minister did write to Lord Morrow regarding that particular issue. It had been actually discovered upon drafting of another piece within the legislation, and at that point the Legislative Council felt there was ambiguity in how the construct could be interpreted. The difficulty is that whilst PPS and other lawyers have a good handle of the law and interpretation, and perhaps the courts, there are other end users in the use of legislation. So we felt it important that that was cleared up and clarified in this particular bill. It does nothing to change the policy intent at all and whatsoever, and the Minister has given that reassurance to Lord Morrow. Lord Morrow has agreed that it has tidied it up. Yeah. But I think he didn't have consider it a need to change it. But I think he did accept that. The Minister has written a couple of times to Lord Morrow. There's been a bit of an exchange, but it does nothing to change whatsoever the policy intent. It's just there to clarify what constitutes an offence for an end user, bearing in mind the end user could be someone that doesn't have knowledge in the law.
In essence, it's a minor technical adjustment. It has no impact on the actual meaning of the legislation. What it does do is makes it crystal clear what it actually is covering. And certainly the advice we got from the first legislative draftsman was, in fact, it was ambiguous and actually could benefit from that tightening up. So it is a tidying effect, but it has the effect of making the law certain. And our interest in putting forward legislation is to ensure that legislation is actually accessible and intelligible to people who use it.
And is it possible for us to see sight of any of the Office of Legislative Council's advice in relation to that?
Well, obviously, as you appreciate, when we get advice from the first legislative draftsman, that is obviously privileged, and as such, I think I've summarised it fairly well. Okay. I'm happy to summarise it further if you want at this or a later stage, but we wouldn't normally offer that advice. And to be honest, this is not in this area. This is not seen as a major change, but certainly it is actually, as I say, where we actually the department discovers that some bit of legislation looks like it's either ambiguous or actually could benefit from improvement. When we notice those things, where we can, we will of course fix them to make sure that they are crystal clear.
You would expect me to do nothing else other than ask, Peter, so that's why I've asked.
No, absolutely. That's why we're here to answer it.
not to cast any dispersion upon the legal profession, but there are a variety of interpretations that could be used from a piece of legal advice, and that's the reason why. So that we're clear in terms of the area of ambiguity.
Well, at the end of the day, obviously lawyers often come to different conclusions about any one piece of legislation, but we have to go on best advice available to us, and where we recognise there is an ambiguity and it's brought to our attention, we feel morally obliged to actually try to fix it.
And just on another issue, and apologies if this is the case, if we haven't, when are we likely to see the proposed amendments on abuse of trust?
At the moment, those are in an advanced state of drafting. Some members of the committee who were here when I was last talking about this will recall I did indicate we were aiming to put this into legislation in the next mandate. But because there had been some developments and there was a lot of stakeholders were very keen we moved quicker, we have done so. But in doing so, we didn't have the time or capacity to undertake the necessary work we would have done had it been going in the next mandate. So to some degree, that meant we had actually to build on what we had. We are fairly far advanced in the development, but in fact, I'm not sure I want to give you a hard time, but I think sometime in the next month or several weeks, we expect that amendment to come forward.
Okay. Maybe a couple of other questions, but I'm going to ask Gemma.
Yeah, thank you, Chair, and thank you for coming in and all the work you've done on this. I know there's currently a consultation running on non-fatal strangulation offences.
Yes.
So in terms of the Minister's amendments, would the Minister intend to bring forward an amendment on this issue alongside the abolition of the rough sex defence?
The short answer is no. Primarily because at the moment the rough sex defence is very much one which what we're doing is actually turning what is a current common law practice into statute. That actually consolidates it and actually means in fact we can tighten it slightly. But in essence it's actually building on an existing common law set. When it comes to the non-fatal strangulation, we're actually developing some new policy in this area. Okay. The actual consultation on non-fatal strangulation isn't actually over yet. It's not over until the 17th of September. Okay. So, as you'd expect, I'm loath to have written the policy before I've actually finished consultation. Otherwise, actually, the same groups who, in fact, are very keen that the Parliament consults on policy matters before we reach the conclusions would actually be will be on top of me. So, in essence, in fact, we are clearly taking this seriously. It takes time to develop policy. I have to actually look at the consultation, analyse it, put advice to the Minister. She will advise me what she wants to do. From that, we then move towards a position where we draft instructions, we go back and forward with the parliamentary solicitor, we go to the first legislative draftsman and his team, and that's when, sometime after that, we've got to the actual policy. I think, clearly, I know there will be a temptation in some quarters to say, well, let's just fold it in by way of amendment. But the danger is, I much rather actually develop good quality policy built on consultation and careful thought. But the danger of actually doing things quickly is, in fact, we get them wrong. Yeah. And this is an important bit of legislation. I'd much rather it goes in the beginning of the next mandate in a mature form, which is capable of being enacted, and actually which will make a real difference to protecting the lives of mainly women, but women and men who actually are subject to this sort of assault.
Yeah, no, I appreciate that and I understand completely. There were other issues that arose from the review of the law on child sexual exploitation that haven't been included in the bill, including criminalising the possession of a so-called child sex doll. And why has this not been included?
Well, on that one, ultimately, in fact, what we did do, and in the consultation, the responses we came back were much less clear-cut. And ultimately, in fact, we didn't really feel we had enough grounds to actually say that should be excluded. Now, clearly, it is a difficult area, and it's something we will keep under review. But certainly, on this case, the incidence of these things, it seems to be enormously rare. And secondly, actually, on consultation, we didn't really get very clear-cut responses. So, in fact, on balance, we felt this wasn't actually a priority at this stage. Clearly, we'll be open to change downstream if, in fact, it looks like this is an issue. But to date, we haven't really got a strong sense it has been a major issue or a major concern.
Okay. And just one more question, Chair, sorry. Regarding clause 4 around the extended anonymity of victims, the Department originally wanted to extend it indefinitely after a victim's death, but reverted to 25 years, following concerns raised by legal advisors. What were the concerns and how did you settle on the 25 years?
Well, ultimately, I think what the advice we got back from lawyers was, in fact, indefinitely was actually problematic after death. Clearly, there are a number of quite legitimate reasons where people downstream may want to actually access information about people who maybe in their writing books or doing various other things. What the proposed legislation does allow for the court to vary or disapply, I think, where necessary. Equally, in fact, potentially it could presumably be increased. But the advice we got from our legal advisors was that really you had to put a date on it, and actually just putting it indefinitely would actually be too drastic a solution. We thought 25 years was sufficient. It's more than nearly 2 generations. We felt it was sufficient time that any likely issues about reputational damage or whatever would be much reduced. And it was a balance. Certainly it could have been more or less, but in fact we came to the conclusion that was a reasonable sort of, it would give a reasonable gap after the person had died, so any reputational or other issues would probably be much reduced. So again, we're open to discussion as we go through, the bill goes through its passage, but it did seem to be it was a balanced judgment.
Yeah, no, that's great, thank you.
If I could just add to that.
Yeah.
During drafting of the legislative provisions, the legal advice was that it wouldn't be proportionate in law for an indefinite period, as Sir John had recommended. And this was on the basis of ECHR Article 10, freedom of expression, where someone couldn't do that within a permanent period. What we had to do then was try to establish a proportionate period that would somehow recognise a period of time that could elapse. So as Brian rightly points out, the recognised generation gap is around 20 to 30 years. So we went for midpoint at 25 years. That, in our view, is proportionate. We have, as Brian says, there's an ability for persons to make an application to the court to modify and vary in terms of increasing or even decreasing that time. There may be reasons why a person would want to discharge that period in terms of a victim's family. There might have been a wish that they wanted something published and their voice to be heard after their death. So we've taken all that into consideration, and with the people that are able to make an application and that they're the right and proportionate people, in our view, to do that. So that just adds a wee bit of clarity. I hope that's helpful.
Yeah, that's really helpful. Thank you very much. Thanks, Chair.
Thank you, Gemma. And Brian, thank you for smashing the glass ceiling that the policy is not written before the end of the consultation. You've really given me a real assurance, because there was me believing that was the process, the way that was done all along.
Well, when I joined the civil service, I'm not sure that was the case, actually. In fact, I have been involved in policy for most of the last 40 years, and I have run many consultations, and I can assure you, Mr. Chairman, I have always listened very carefully to what came out of those, and have often changed my views as a consequence.
Well, that's reassuring to know, and thank you for that. Peter.
Yes, just a couple of, because a number of the points have been covered already. I suppose just 2 points. You mentioned, I think, in terms of the anonymity issue, that in terms of those that call it either exempt or those that, in terms of those who were allowed into court. And those
Exclusion,
I should say exclusion rather
yes.
than that obviously it was those there to support a witness. So I presume that's the sort of reference that either for the complainant or defendant to have at least one name supporter. Because I think we can all appreciate there'll be circumstances in which either a defendant or a complainant may feel very vulnerable if they're in simply a
that's correct,
position
yes.
on their own. Second one, I just want to raise, and again, I don't have any particular objections to this, but I suppose just to test out whether this is just to provide a level of catch-all, or whether it's something that's driven by practical issues in terms of numbers. Obviously, the specific reference to either sort of slavery or compulsory labour outside of a trafficking situation. And I'm just wondering, has that something that's been happening in practice on that basis, or is it simply to cover beyond simply the trafficking scenario?
This is in relation to the exclusion, is in relation to serious sexual offences.
Sorry, I'm talking two separate issues.
Sorry. Moving on to the trafficking.
I'm moving on to the trafficking issue.
Sorry, I beg your pardon.
Right, for once, an MLA student movement has gone beyond
Sorry
that.
about that.
No, it's not to do with the exclusion, but in terms of the broader modern slavery issue,
okay.
Obviously then there's then provision that where it is slavery or the compulsory labour outside of or beyond just simply a victim of trafficking.
Okay.
And I can understand, I have no objection if it is on the basis of simply saying this is a catch-all situation to make sure that nothing falls outside the scope of it. But I'm just wondering whether there's any issue about tackling a current life practical issue. Are we getting many cases where there is that proof of either effectively modern slavery, compulsory labour beyond what is happening in a trafficking situation?
Well, I think actually I'm probably going to refer you to one of my colleagues and the Starley on the basis that they will have the expertise on this aspect of the bill. But certainly, I suspect it is just to make sure we cover the
Yes.
ground. I wonder, Alison, do you or Ronnie want to pick this up?
Yes, so this change is really just to put into practice the policy that's already in place. At the moment, as set out in the legislation, we have support for victims of human trafficking, but in practice we also extend that support to victims of modern slavery where there is no element of trafficking, and that was a policy announcement back by the then Minister in 2016. So this is simply to put that practice onto statutory footing. I think most cases that we deal with involve an element of trafficking, and this is just a way to provide reassurance that anybody who falls under the modern slavery umbrella is entitled to support provided by the department under its support contract.
Okay, thank you.
Can I welcome Alison and Ronnie? It's good to see you. And apologies I didn't get welcoming you at the start, but you're welcome to the Justice Committee.
Thanks very much.
Rachel, you have some questions.
Thank you, Chair. Thank you for the briefing and for outlining the bill that we have in front of us. Obviously, this is a different bill than what we had originally expected and proposed, but I suppose it's important that we have it now. Chair, if you'll oblige me, I have a number of questions just on Clause 1. And this is the creation of the new sexual offences of upskirting and downblousing, which are included in this clause. So I note just from the way that it's worded that if certain criteria and purposes are met that have been outlined, so sexual gratification or for humiliating, alarming or distressing the victim. So we have the act itself, which is the downblousing and the upskirting being criminalised for the purposes of sexual gratification or and recognising the impact of such an act having been had on the victim. But I'm just wondering, with regard to the purposes, were there any other motivations considered by the department in the creating this offence aside from sexual gratification or the impact of the victim?
I'll maybe pass over to Lorraine in a second, but just to start off with, clearly this is, we've both taken on board what practice has been developed across other countries. So we've looked at actually practice elsewhere just to see what actually works practically. And of course, what we also want to put a careful balance between what is an offence and what isn't, because there may well be some circumstances where we wouldn't want to criminalise inappropriately people where there hasn't been sort of malicious intent, if you like. So it was a question of trying to get the right balance, but no doubt Lorraine can actually give you much more detail than I possess at the moment.
Thank you very much, Brian. Yes, as Brian says, we did take into account the experience and the legislation in other jurisdictions. As you know, as it stands, upskirting in Northern Ireland, there's no offence, and we are very much in a gap in the law in that respect. And downblousing will be unique to Northern Ireland. There is a downblousing offence in the Republic of Ireland, but in terms of the UK, the motivations were considered on the basis of sexual gratification and then with intent to cause alarm, distress, simply because we wanted to separate out those serious offenders, those people with a sexual gratification. Not everyone that will commit this offence will have that in mind, and it was important that the two motivations were there for that reason. In terms of the sexual gratification itself, if I'm rightly understanding your question, we have basically legislated in line with the approach taken in England and Wales, and simply because whilst we did consider everything in the round in terms of the other pieces of legislation, our framework is closest to the England and Wales model. But in saying that, I can assure you that we did consider this from a policy perspective, that this fulfills our policy needs. It wasn't a case of just copying that or mirroring that without thinking about that. And as I say, the two motivations are important because they do separate out a bit of a childish prank from someone who has clear intent to do something more malign. I hope that answers your question.
Oh, yeah, no, absolutely. And I know just from looking at the other jurisdictions, in particular England and Wales, that it's been noted that there are gaps in their and sort of loopholes and areas that could be enhanced by further sort of amendment in their experience. So I'm just wondering, has that been considered?
No, the short answer is no, we hadn't considered that.
In essence, we clearly have been in conversation with our colleagues in England, and to some degree, I think you can always wait. There's always a dilemma between putting legislation in and waiting till you get a perfect model which actually goes. So in fact, we felt that rather than actually, I know there may be some additional work going ahead, and it may well be downstream, this could be broadened, but in fact, certainly, the Minister was very keen that this was moved forward. She did not want us to hold fire to the next mandate and beyond, to make these offences. We see this a present and immediate issue about actually people committing this sort of offence in those areas. And whereas I'm sure any bit of legislation we ever develop could always be improved, the question is, when do you actually strike? And I think the Minister was keen that we moved quickly on this one. And no doubt, as developments in England or other parts of the world occur, this is something we can obviously refine. But certainly, I suspect what we're doing covers a great deal of the ground, and I'd be very nervous about waiting. Sometimes the best is the enemy of the good. And I think in this case, the Minister wanted actually to move reasonably quickly to get a number of these offences actually included in legislation.
And certainly we will look into that, if that gives some reassurance.
But I think that review may well actually extend well beyond this legislation, because, let's say, in England, they may well... The advantage of actually having legislation is you start to find where there are gaps, and where we can steal a march and build on that learning to actually improve our proposal, we'll do so. But it's not at that stage yet elsewhere, and we didn't want to delay on the basis of perhaps getting a marginal improvement, but at the cost of a considerable period of time.
Okay, thank you. Well, that's grand. In terms of, it might just be one for the PPS, but I'm wondering how is sexual gratification proved in general? For here in this case, sort of what tests are going to be put in place or are intended to be in place to prove that upskirting or downblousing was done for the purposes of sexual gratification? Do you think there's any danger that the burden of proof would be too much for sexual gratification as opposed to the proof of humiliation and the impact then of alarm or distress on the victim? Because, as you said, it is an important distinction.
Well, I think, in fact, ultimately, that's not a question that we can answer in terms of the policy. This will be certainly where the police and others will apply their own knowledge base and skills. But as a relative layman from the Department of Justice, my assumption is, in fact, where actually someone's doing this and then putting it onto a website for titillation or some particular groups of people who are interested in sexual activities, that would be very clear cut. Ultimately, in fact, what our aim was, in fact, we recognise that amongst those people who may well be guilty of such an offence, there may be a number of people who just do something stupid. But you could also, amongst them, have some quite nasty people who are actually doing this actually to really to degrade women and actually to further their own sexual sort of proclivities. And where they're actually doing that, and we actually do find that there is evidence that this is actually being shared, distributed, or used in a way which is perverse and objectionable, that would clearly give the capacity to have that person put on the sex offenders register as well, which I think is an important distinction. Other times it may well be, you could conceive a situation where an individual has something against another individual and does this just to humiliate them, or in fact and there may be no sexual content whatsoever in that. Yes. Now, it doesn't actually mean that somebody might not see it and then use it for sexual content, but the intention there was to pay someone back or to get revenge or whatever. In that area, that's quite different, and you wouldn't put them onto a sex offenders register. And certainly you would have a different concern about those people. So I would have thought in the broad categories are probably relatively clear cut, but when it comes to the fine distinctions of how you determine whether there's an intention relating to sexual gratification, I think we'd have to leave the police and others to look at the circumstances of the situation, and it would be on the basis of the evidence that they'd make that determination. So I didn't answer your question, but I hope I gave you a sense of how complex this is, and actually how much you're very much relying on the circumstances.
Absolutely, no, I appreciate it. It's incredibly complex. I just think it's important to have, there's the two purposes are there, and I don't think they're covering everything, but I mean, and we touched upon that in terms of people could be using sort of downguising and upskirting and to humiliate a person, and maybe for blackmail, but also as as part of coercive control, and the committee just finished obviously long deliberations on domestic abuse and coercive control, and do you think that using sort of these as part of domestic abuse, for example, or indeed even sort of any form of abuse and coercion is covered enough in this clause?
The short answer is this is one of a suite of pieces of legislation the Minister's either has introduced or is introducing. Clearly, the committee has already made its own mark on the domestic abuse bill, which is now, of course, law. The prevention from protection from stalking bill is with the committee at the moment, and that's another component of that. And this actually, elements of this bill are a third component. So taken together, the Minister and the Assembly will be substantially strengthening the protections of women, primarily women, but not exclusively women, in these sort of situations. And you're quite right, the whole issue about upskirting or downbanding could easily be linked into actually stalking. It could easily be linked into domestic violence or domestic abuse. And certainly on the coercive control, that could well be a component of it. So in fact, these things are all interlinked, and all those legislations taken together substantially strengthen the protection of victims in Northern Ireland.
And if I could just add as well that the proposal where the legislation we're proposing in the consideration stage for extending the scope of revenge pornography to threats. Often revenge pornography is carried out by means of a coercive control element in a partner relationship, so that will strengthen it further.
Great, thank you very much. Finally, just on this clause, does downblousing cover breastfeeding?
It's where if it's not ordinarily visible, if the breast is not ordinarily visible, then it would be an offence for someone to observe or record. But I hope good sense would prevail in terms of consideration by the respective authorities in applying the legislation.
But it just on this, the way that the bill is currently worded, it doesn't explicitly cover breastfeeding.
Yes, but I think the way it is worded in terms of what would ordinarily be visible, if someone has a low-cut top, for example, you know, it wouldn't be fair to suggest that, you know, if that's already, you know, exposed, this is where it's not ordinarily exposed and it's without a person's consent.
It is about gaining access to images which would not otherwise be available,
Yes.
not readily available. So, in fact, in breastfeeding, if a woman is feeding a child and the breast is exposed and it's not really seen as actually, I don't know, I can't see, I'm not quite sure it would fit into sexualised or degrading the principles behind this, but in fact, certainly the aim is actually where people are, in essence, trying to gain access to images which would otherwise be unavailable.
Yeah.
Clearly on the breastfeeding side, where someone is breastfeeding, that is a natural, normal process, and as such is not particularly, not as private, if you like. And indeed, I know campaigners will argue it's a right of all women to breastfeed anywhere which is appropriate when the child is hungry. So it seems to be a different category of situation.
Yeah. And everything will be considered on a case-by-case basis as well, you know, depending on the circumstances of the case and how people feel. But I agree with Brian, it would be.
Because of course, you know, we do recognise, in fact, you know, what you're aiming to do is criminalise that sort of behaviour where it's a sexual dimension or degrading or sort of situation. You also get actually various pop stars gallivanting in fields in Northern Ireland, waving their bits actually quite happily for photographs, you know, and that clearly isn't actually against the law. And again, in beaches and other areas where people are more exposed, that taking photographs in a normal situation would not be against the law. But it's where actually you're trying to access images which would otherwise be available, and you're doing so for essentially a malevolent purpose. That's actually what we're trying to capture.
Thank you. I think maybe sort of you can get my original sort of comments on the purposes, maybe not encompassing everything then that we're maybe needing to look at, and just sort of the way in which the motivations may not capture all sort of instances, but I'm no doubt I'll come back to this on Monday or during the deliberations.
We look forward with interest to see what you want to add to our list.
That's okay, don't worry, you'll definitely pick up on where I'm going with this. Clause 7, Chair, if I may, I'll just ask on this one. This clause has given me some difficulty to get my head around about why it's here. In my understanding, just reading it, that this is setting out some sort of protection for online services or service providers from any legal responsibility for illegal publication where the providers are a conduit for the information. Could you explain a wee bit more about what that is, why this has been included, what kind of websites, what platforms, and is this not getting into territory that is reserved?
This was particular, we had to include this particular provision having liaised with the UK government following Brexit, and it relates to a particular directive and regulations which on e-commerce which encourage the free movement of that around the European area. So given Brexit, there had to be defences included on our domestic law, which would provide for those service providers, usually with sales of goods and things like that, whereby they would be liable for our domestic law, where they have a base here and they are using our service provider for other UK channels. Does that answer your question?
No, sorry, it just, sorry, I know maybe I'm just a wee bit confused just with that still. So this is given legal, this is sort of giving them a protection for hosting illegal publications.
Well, it's not. It's given them a defence that if it is a case of conduit and they're not in any way, they don't know about it. So if it is a case that they do know about it, then that's a different story. But this is where they aren't aware of it, and they can use that defence.
I think there has to be.
It had to be. Oh, sorry.
To commit an offence, you do need to have an intention. And obviously, I think maybe this is trying to pick up a situation where there's a provider has inadvertently, something's happened which they are not aware of and couldn't reasonably be aware of, and consequently, in fact, to actually find them guilty of an offence where they weren't in a position where they made a decision to commit an offence is the issue. But certainly, this is clearly you're quite right that this area is normally a reserved matter. And in fact, this is very much just a tidying up issue to make sure we stay within the appropriate law.
And it was on the advice, as I say, from the UK government to our lawyers, also liaised with their lawyers in this matter, and it has been put in this particular provision because this is a new piece. This provision's a new piece. It also is being put into the 1992, the Sexual Offence Amendment 1992 Act, because that predated the directive, so that had to be put in that guise as well. So it's in two areas within the bill.
And I think certainly more broadly, the government nationally is looking at putting additional protections in relating to service providers. In some ways, we actually, that is a reserved matter, and they take the lead. So our aim wasn't, in fact, to try to solve all the problems of the use of the internet, but rather to make sure we stayed within the law in quite a narrow particular area.
Okay. Thank you. Finally, just on Clause 10, which is the relevant person being able to apply to the magistrates' courts to disapply or modify the reporting restrictions in Clause 8. Within it, there's mention of family members after a suspect's death. Could you tell me what's meant by a family member, and does that include in-laws and cousins?
Yes, I think that is definitely prescribed, and I'm just trying to find the section where it prescribes the family member. So we have, where do we see now? It's subsection 9. So where do we see 10? Is that 10(9)? That could be the relative means parent, child, grandparent, great-grandparent, grandchild, great-grandchild, etc.
So does it include in-laws or cousins?
Well, we were trying to be as proportionate as we could in that regard, taking into account people who have children and people who perhaps don't have children going forward, and given that particular time period we're talking about. So we were trying to be as inclusive as possible, and we will look to the domestic abuse offence in that regard as well. So it goes, this particular specification goes, I think, wider than the 1999 Act that we're amending. So we tried to be as inclusive as possible.
Okay. That's granted. On the same reference to personal representative.
Yes.
Is this a legal representative only, or what does that term mean practically?
What's that? Sorry, I didn't hear the question.
It may be a legal representative, it may not. It's a personal representative is just what it says. It could be another family member. It could actually be a voluntary organisation. It could be a lawyer.
A legal advocate, basically, for that person. Who may have their wishes, who may know well of their wishes.
Okay. Sorry, I didn't catch the first bit of that. There's some building work going on. I'm not too sure where, but just that personal representative is whoever the person wants to
chooses.
There.
Yes, absolutely.
Who's nominated by the individual to represent their interests.
Yeah.
No, thank you, Chair. That's me. Well, I could go on, but I'm not going to. So.
Thanks. Sinead.
Thank you, Chair, and thank you for the briefing so far. Chair, I won't go over, some of the points have been raised and I won't labour them, but I do want to put on record, following on from what Rachel said there in Clause 1 in the new offence, there has been a clear distinction made today, which is helpful in terms of the distinction that's being made between a prank and a sinister intention. But I still am not convinced operationally how the bill as it's written at this moment in time is going to be helpful. And I do wonder if any consideration has been given to the possibility of a reasonableness test So whilst it references the intention of the person, you know, be it for sexual gratification or humiliating and alarming and distressing the person, should there be something in there in terms of perhaps reasonable, like a reasonable person could come to that conclusion? Because I just think operationally I'm not sure, or I don't fully see how this could work. And I don't know if the department have had any thoughts on that, and maybe we as a committee could explore it more, but just anything that the officials, while they're here, want to maybe add on that would be helpful. Thank you.
I just wonder, can you expand a bit on what you mean by a reasonableness test? A reasonable test of what? That there has been, that a photograph was taken with an image, that it was sexual, that it was... I'm just trying to clarify, when you say a test of reasonableness, what do you...
Sorry, I think the fact that the image has happened, you know, that should be evidential. I can see how you could prove that has happened. But how do you prove the intent? How do you prove that it was for sexual gratification, or how do you prove, and it may be, as has been suggested, it could be easier to prove if it was to humiliate or alarm, because there may have been an action that has taken that creates evidence of that. Yeah. But I'm not sure how you create evidence of it being for sexual gratification. So would it be appropriate to consider at that point that a reasonable person could come to the conclusion that that was the intention for the image being taken?
Sorry to interrupt a wee second here. I'm just wondering, just to pick up on Sinead's point, the only thing I'm thinking in terms of reasonableness in that context, does that not cut across burden of proof? Because presumably to prove the offence, the element of intent, as with other elements, would have to be beyond reasonable doubt rather than... Maybe we're sort of...
I think you might be trying to apply almost a double test here, because ultimately, if you look at the sequence, someone takes a photograph up someone's skirt, he then publishes that photograph on a boy's thing of sexually the sexual images. At the end of the day, that's seen by someone, it's reported to the police, and the police sees the camera, they find evidence, they seize his computer, he finds that image has been widely sent around, possibly with accompanying comments which reinforce the message that this was of a sexual nature. That would actually go to the Public Prosecution Service. They would make a judgment call, and they when they're taking a decision about prosecution, will say, is this something which actually is demonstrable, has a reasonable prospect of conviction? When it goes to court, certainly the judge or a judge and jury will make a judgment call. They will actually test the reasonableness of the evidence, and it will be against the high standard of beyond reasonable doubt. So, in fact, I'm not sure interposing a test of reasonableness in this sort of area would actually be very, very easy to do, or actually add any value. Certainly, this is where those cases go to court under a sexual motivation. The police will have to have actually gathered substantial evidence which they actually can stand over, and which the Public Prosecution Service is sufficiently happy with that it proceeds to allow prosecution to proceed. And then the judge makes that test of reasonableness as part of actually looking at the evidence. So I'm a great fan of test of reasonableness. In fact, you'll find there's one actually in the protection from stalking bill. So where they are appropriate, they're very useful. But in this situation, I suspect this is all going to go down to the evidence that can be gathered, and then actually trying to analyse that. And I would expect, to be honest, both the police and the Public Prosecution Service, probably as part, well, certainly the PPS as part of their prosecutorial test, will look at the evidence and the public interest test. But in fact, I suspect there's a test of reasonableness they apply probably as part of that process anyway.
And it's very important to I have to say that is proven, because this will then be a sexual offence for the purpose of notification requirements and follow through public protection arrangements. So it's very important, and as Brian says, I think it will be on a case-by-case basis, and depending on all the evidence that's gathered around it. But it's certainly a question we can put to the PPS, and I know that they will probably be answering in terms of your calls to evidence. But
yeah, perhaps maybe if you're talking about test of reasonableness, you're concerned not about actually people who are going to end up in the courts, but actually on the other end, people who are on the margin, and maybe a reasonable person would have said, well, that was an innocent act. If that's the case, I'd have thought the police will certainly want to be very sure of the evidence before they put something forward, because clearly there are innocent acts you could have. One could accidentally have taken a photograph, not intentionally. One could actually be doing it with consent, taking a photograph with consent. One could actually have, and there may be other circumstances where a photograph is taken which had no malicious intent and no sexual intent whatsoever. And clearly the aim isn't in fact to criminalise people, but the aim is to ensure where people have got malicious intent, whether it's actually in terms of actually degrading or abusing the person or actually getting sexual gratification. We want those to be prosecuted, and to do that, evidence has to be available, and it has to be sufficiently strong for it to go to court and for a conviction to be secured.
Thank you. I do take your point about when it's weighted against, I suppose, other things, and we look at the stalking legislation, for example. So it may be that if a phone is confiscated and the police are analysing that phone and an image comes to light, that there may not be, a sharing of that on other. It may be for personal use only. And in which case then the sexual gratification would be harder to, I suppose, to prove. But then in a framework around stalking, what I could say is that it would be reasonable for somebody to assume that that's why they had the image on the phone. And also I just wanted to, because it is that there are the two there, it's not and or, they're two separate things. So it could be an offence just for obtaining for sexual gratification, or humiliating, alarming or distressing be. Would that be fair assumption?
I think in fact I said earlier on that in fact the Minister has put forward that essentially 2 or 3 separate bits of legislation taken together provide a good degree of protection. It could well be that in fact the image was not particularly to humiliate. It may not have been sexually gratification. It could be part stalking, but at the same time that the police found that in the phone when there was a query about this, and there was a complaint about being stalked. This could well provide evidence on the stalking offence. It may not actually score against upskirting, because it may well have been it won't have met those criteria, but it could be part of coercive behaviour, like coercive control. And it could be part of that sort of obsessive behaviour which actually the stalking bill is seeking to cover. So it wouldn't be that situation if there was no proof at all about sexual gratification or humiliation, but at the same time it was part of a pattern of behaviour which was consistent with actually stalking. Then the person could be prosecuted under that legislation once it's enacted.
And there is no doubt that the person, if it is for sexual gratification, they're also humiliated. But this is about separating out the two motivations and what they're doing, with the sexual gratification being the more serious of the two in terms of going forward with notification requirements and so forth.
Thank you. I appreciate your feedback, and I won't labour on that, but I think there is a piece of work perhaps maybe still to be done there. But thank you, and thank you, Chair.
Okay, thank you, Sinead. Just to conclude, unless there's any other questions members have, and apologies, Brian, if this was covered, but has the Minister agreed, or what has the Minister agreed in regards to extending the positions of trust?
What we're doing in the legislation, or what we will do in the legislation, is actually to extend the abuse of trust legislation to cover sporting and religious type activities. Now, in taking this forward, we've also actually included, or proposing to include, a clause giving a power to extend that beyond those two areas. Had we had more time to actually go through this policy development in great detail, I was, for example, interested in actually extending it beyond that, but realistically we just didn't have the evidence to underpin that. So there's quite clear evidence of support from the sporting and religious communities that for this particular sort of for this particular legislation, alongside the NSPCC and other victims groups. So essentially we are focusing this on sporting and religious circumstances, but with a capacity to extend that to other areas as we can gain sufficient evidence and understanding to suggest that would be helpful. Clearly the two biggest areas of concern were in sports and in religious organisations. There may well be other sort of areas in the future which we might pick up. But in reality, since the Minister was keen to bring this forward now because of the lobbying of various groups, and indeed actually from MLAs and others expressing their own concerns about this, we've done this sooner than I said we would when I was last here. But the consequence of that is, in fact, we haven't had time to go through the very detailed process which we would have normally done in policy development. And we haven't got sufficient evidence to go beyond where we've gone at this stage.
In terms of that designation of religious organisations, are you intending that would include uniformed organisations?
Where they actually have a religious background, yes.
Yes.
No, clearly there are some uniformed organisations we have no religious association.
No.
It's more aligned to faith in
Yes.
terms of, the churches and so forth.
Right.
I could also add, Chair, that it is important, and it's in this particular policy more generally, that we apply a degree of proportionality to how we move on it effectively and extend the scope. The policy is about balancing the needs of a person to protect a person who is vulnerable to being able to engage in a healthy consensual relationship. And if we were to extend it too far, there is a danger that we basically increase the age of consent to sex here by stealth. I suppose there was an issue around that, and it is about ensuring that the right balance. And also, as Brian said, we would need more engagement and consultation around those areas that we're not looking at this stage.
Okay. Thank you. I really do appreciate that clarification. And I think if there's no other questions that members have, can I thank Brian and Lorraine for being in person here, and also to Alison and to Ronnie, and can I assure them that we'll maybe give them a more challenging time the next time they come to the department. Ronnie got off very easy there, I think. So,
thank you, Chair.
So thank you. And obviously the second stage of the bill is moving on Tuesday.
Yes, so very soon now.
Monday?
It's progressing. Thank you very much. Thank you for your time.
Thank you.
Yeah, it may actually be Monday, actually.
Sorry, Monday. I
Monday,
apologies.
yeah.
Monday. Thank you for that correction.
Thank you very much. And we look forward to a future long and fruitful association in the coming months.
Thank you.
Thank you.
Thank you very much.
Thank you.
Okay, members. Obviously, we want to seek the views on members as whether they are content to support the principle of the bill at the second stage. Content?
Great.
Great. And the second stage of the bill is listed on the order paper for Monday, as Brian has reminded us, and I will reflect the views of the committee during the debate, as I have no doubt members will also make their contributions. So you can be busy over the weekend. Rachel, get your pen ready and your speech ready for Monday. Okay, members, thank you. You were maybe writing it whenever the committee was going on there. That brings us then, members, to item 6 on the agenda, which is the Police Crime Sentencing and Courts Bill proposed legislative consent motion. The committee has been considering the provisions within the Police Crime Sentencing and Courts Bill for which the legislative consent from the Assembly will be required for some time now, and has sought the views of a number of organisations, the Human Rights Commission, the Attorney General for Northern Ireland, including on the culpability with the European Convention on Human Rights. The Department's response to the issues raised by the Attorney General and the Commission was considered on the 27th of May and referred to the Human Rights Commission for its views and comments. Further response from the Human Rights Commission was considered at the meeting of the 24th of June, and the committee agreed to forward to the Department for response to the issues highlighted, along with a number of specific issues raised by the Committee. The Department response dated the 17th of August, which includes comments from the Home Office, addresses each of the issues raised by the Committee in turn. And the Department has also advised that a further provision may be included in the LCM, which relates to the use of audio and visual links in criminal proceedings, which, if accepted, would require executive approval. It is not, however, clear if the inclusion of the provision has been proposed by the Department at Westminster, or what impact this may have on the timescale for the LMC. The Committee has agreed to consider or advised that the Committee had agreed to consider if an oral evidence session with departmental officials should be scheduled following the receipt of the Department's response. Although the LCM was not laid during the week commencing the 30th of August, as the Department had indicated, it is expected that it will be laid at the earliest opportunity. Understanding Order 42A7, the Committee will have 17 days in which to complete its deliberations and agree its report to the Assembly when the LCM has been laid. At the time, obviously, is very limited. Any additional information, either in writing or by way of an oral briefing, that members require to assist its formal scrutiny of the LCM needs to be requested now. So we do have there is an issue there that I think at some stage we may have to refer to the procedures, the people who look after standing orders, because 15 days is a very, very short period of time for officials to turn around and for a committee to turn down a report in relation to an LCM. So that may be an issue that maybe even initially could be referred to the Chairperson's Liaison Group, or can we refer it directly to the Standards and
Procedures
the Procedures Committee?
If the Committee wants, we could write and highlight that we've got a fairly substantial LCM, and the timescale within the standing orders doesn't provide very much time, and they may wish to look at that.
We have enough that we do that. Agreed? Yes? Great. Thank you. We need to seek the agreement of members to ask the Department for more information on the additional provisions relating to the use of the audio and visual links in criminal proceedings, including clarification on who is proposing the inclusion of the provisions and what impact this may have on the timescale for the LCM. Agreed?
Great.
Also, on whether we are otherwise content to note the additional information provided by the Department, and whether any further information or clarification is required in writing or by way of an oral briefing, or whether members wish to submit any views or comments in advance of considering the legislative consent motion. Any comments?
Rachel.
Okay, Rachel.
Thank you, Chair. No, content with that, and also to forward the reply, if we can, from the Department to Northern Ireland Human Rights Commission for comment. But if possible, I'm wondering if we would be able to request some further information on the section which is the effective risk management processes agreed between police forces and probation services across the UK that are already in place, and that identify and manage offenders moving between jurisdictions. That would be in relation to the sexual harm prevention orders and sexual grip orders that are cross-jurisdictional. Okay,
yes. On those two issues, members agreed? Agreed. Thank you. Thanks, Rachel, for that. Okay, if there's no other issue in regards to that item, we move on to item 7, which is the Statutory Rule 2021/173, the Disclosure of Victims and Witness Information Prescribed Bodies Amendment Regulation, Northern Ireland 2021. This information for members is at page 361 to 370 of the meeting pack and at pages 9 to 14 of the table pack. The statutory rule will add the new advisory service AssistNI to the list of prescribed bodies with whom the PSNI can share relevant information about victims of domestic and sexual abuse crimes for the purpose of providing support services. The Committee agreed at its meeting on the 27th of May that it was content with the proposal of the statutory rule, which is subject to negative resolution procedure. The Department has advised that there has been no change to the policy content since the SL1 was considered by the Committee and the examiner of statutory rules has no issue to raise with regards to the technical aspect of the rule. Are members content with the statutory rule? Content? Okay, then I will put...
No, I was just going to say I've no problem with the statutory rule. Such it just may be useful in terms of a couple of pieces of information just we got just alongside that. Okay. Is I suppose, are they able to provide us a readout of the full list of the organisations, and in terms of the information that we're able to share, can we get any details if there's any particular limitations? No, but I don't particularly want to hold up the statutory rule.
Yeah, okay.
Regard, but just
okay, so we can ask for that information, and then if the committee is content with the rule, can I put the question, the Committee for Justice considered SR 2021/173, Disclosure of Victims and Witnesses Information, Prescribed Bodies Amendment Regulation, Northern Ireland 2021, and has no objection to the rule. Agreed?
Agreed.
Thank you. Rachel, I'm just checking. You maybe haven't taken your hand down. Just, are you okay? No problem. I'm just trying to keep an eye on all these things. Agenda item S1, which is another statutory rule 2021/183, the Criminal Justice Sentencing Licence Conditions, Northern Ireland Amendment Rule 2021. You'll find this information at pages 372 to 388 of the meeting pack and pages 8 to 14 of the table pack for the relevant papers. The statutory rule will provide that the Department with discretion to assign the lead statutory responsibility for the management of the terrorist risk offenders on licence to a body other than the Probation Board for Northern Ireland, with whom sole statutory responsibility currently rests. Having considered further information from the Department of Justice on a range of issues relating to the policy intent behind the proposals to change the arrangements for the supervision of offenders on licence, the committee agreed that it was content with the proposal for the statutory rule, which is subject to the negative resolution procedure, at its meeting on the 15th of April. The committee also requested details of the final criteria for the terms of reference when available. This was provided by the Department on the 27th of August and is included in the meeting pack. Previous correspondence from the Department, which includes the current final criteria for the TROs, has also been included in the meeting pack for your information. The Department has advised that there has been no change in the policy content since the SL1 was considered by the Committee, and the Examiner of Statutory Rules has no issues to raise with regard to the technical aspects of the rule. Are members content with the statutory rule?
Right.
If members are content, can I put the question that the Committee for Justice considered the statutory rule 2021/183, Criminal Justice Sentencing Licence and Conditions, Northern Ireland Amendment Rules 2021, and has no objection to the rule? Agreed. Thank you. That brings then to item 9, the proposed transfer functions order, transfer of the appeal services and the rent assessment panel to the Department of Justice from the Department of Communities. This information is at page 390 to 392 of the meeting pack. The Department has written with regards to a proposal to transfer the appeal service and the rent assessment panel from the Department for Communities to the Department for Justice from April the 1st, 2022. The panel supports the functioning of tribunals, which are mainly concerned with appeals against decisions made by the EFC in relation to social security entitlement claimants. Following executive agreement in 2010, the majority of tribunals were transferred to the Department of Justice in April 2011. Agreement was not, however, reached at the time for the transfer of this panel, and it was agreed in 2012 to postpone its transfer to allow time to assess the impact of the welfare reform arrangement and embed the oversight structure and funding arrangements provided by tribunal reform. In the meantime, the Northern Ireland Courts and Tribunal Service has managed all the operational matters relating to the panel under the service level agreement, and the Department for Communities has retained statutory responsibility for the introduction of all the policy legislation and regulations in respect of the appeals process. Both ministers have now agreed to the transfer of the panel, and this will be taken forward by the First and the Deputy First Ministers by the way of a transfer of functions order. The Department's paper sets out key issues on the work that is ongoing, which relate mainly to the costs associated with the transfer. The Department states that further consideration will also be given to the impact of COVID-19 has had on the ability to list appeals and the high adjournment rate in respect of the production of relevant evidence for the Tribunal panel. So can I ask members to agree to the request further information on a number of following three items? What will happen if the funding assessed is found to be insufficient? Will the Department for Communities be required to provide additional funding? That's the first. Secondly, when is it expected that any additional costs that potentially arise from the O'Brien case will be known, and who will be responsible for these costs, given that they will have been incurred prior to the formal transfer of the panel to the Department of Justice? And thirdly, what is the current adjournment rate in respect of the production of relevant evidence for the Tribunal panel, and what steps have been taken by either the courts or the Tribunal Service or the Department for Communities under the SLA to address these issues? So those are three queries and three questions. Sinead.
Thank you, Chair. I appreciate those, and I do support those three proposals. But I'd just like to place on record, I've always had a concern about this, because I think there's a very unhealthy relationship between people feeling that they're claiming their entitlement to benefits and then being subjected to what is seen as the courts and justice. And very often we must remember that tribunals are about people not getting access to their very basic entitlements. And I'm just conscious that with this panel officially moving over, I think we need to be very mindful of the culture that is developed around this, and that people are not in any way blocked or discouraged from engaging with the process of getting access to their benefits because they are fearful or disengaging with what appears to be a justice piece. And I just think it's a big cultural thing that shouldn't be lost in this. People should have access, and I would urge the First and Deputy First Minister to, whatever piece of work they propose on this, that they put the person at the centre who has an entitlement to benefits, at the centre of all their thinking, and try and make it as accessible as possible. Thank you.
Thanks, Sinead. And I think too, for those of us who have done appeals and used the Tribunal Service, there always maybe was an issue, albeit it never seemed to transpire into any substantive evidence that there was a conflict of interest, in that the department who was in a sense responsible for providing all the information was the department who were also responsible for the legislation, albeit at an arm's length distance, given the Department of Communities and its relationship with the Department of Work and Pensions. So now that has worked out reasonably well, but I do take the point that we need to ensure that at all times the claimant, the person who is making the appeal, does not feel either that they have been disadvantaged by the way that the process has been constructed, or B, that they are in any way being, because now it comes under the Department of Justice, that somehow this is some very criminal point of view. And I think, to be fair, what we should do is we should collate that into a correspondence, and if you're agreed, send it to the First and Deputy First Minister's office.
Great.
Agreed? Thank you. Okay, Sinead, no, we just checking that you'd asked. So, members are content, and obviously the committee will consider this matter further when the responses have been received. Item 10, the Special Education Needs and Disability Tribunal Amendment Regulation, Northern Ireland, proposed consultation. This is at pages 394 to 462 of today's pack. The statutory functions to make changes to the procedural regulations governing special education needs and disability tribunal, which has erroneously remained within the Department of Education following the transfer of the tribunal in 2011, was transferred to the Department of Justice earlier this year. So the Department is now proposing to undertake a consultation and proposals on amendments to the regulation that govern the procedure of the Special Education Needs and Disability Tribunal. The amendments are required as the Department of Education intends to commence special aspects of the Special Education Needs and Disability Act, Northern Ireland 2016. The consultation will be issued to interested stakeholders and will run from the 13th of September to the 5th of November. A list of those to whom the consultation will be issued is included in the consultation document. So just to seek agreement from the members of the committee to ask the Department to clarify why it is a targeted consultation and how it identified individuals and organisations for inclusion in the list of consultees, and also to seek the views of members on whether they are otherwise content to note the proposed consultation and consider the matter further when the results and the proposed way forward are available, or whether they wish to submit any views or comments at this stage or require any further information or clarification. Are we content?
Chair, I have to
Peter?
go. I'm just going to say I have to head on. At this
Yes,
stage.
okay. How does that affect our quorum?
We're okay with a delegated vote from Emma, so as long as no other members.
As long as everybody sticks with us, we'll be okay. Okay, Peter, thank you.
Cheers, thanks.
That brings us to item 11, the CJINI Report on the care and treatment of victims and the witness by the criminal justice system in Northern Ireland, and it's an update on the implementation of the action plan to address the findings and its recommendations. That is at pages 464 to 505. So the CJINI Report into the care and treatment of the victims and witnesses by the criminal justice system in Northern Ireland was published in July 2020, and officials from the department, PSNI, PPS and the Victims Support NI attended the meeting of the committee back in February to provide an update on the delivery of the multi-agency plan to address the findings and the recommendations of the report. Following the oral evidence session, the committee requested an update on progress to implement the action plan in 6 months' time. This is just to advise the members that the update provided by the department indicates that most of the actions in the plan have either been met or partially met, and sets out details on the progress that has been made. And this is to ask members to note the update unless there is any further information that members require. And we just seek the views of members on whether a further update should be requested, maybe, and we should set a marker in terms of March 2022. Agreed?
Agreed, Chair. And sorry, Chair, just to welcome this, because I think further information would be required, because we were committed to monitoring whether victims did have access to charters, and I think having repeated access to this information should give us a broader picture of whether there's actually a real effect. Okay. So I think it has to be welcomed. Thank you.
Thank you for that, Sinead. That brings us then to item 11, the legal aid for mediation in non-family civil cases, post-consultation report and the proposed next steps. Page 507 to 544. The Department has provided a written briefing paper on the outcome of the consultation on the protocols and the arrangement for legal aid for mediation in non-family civil cases. The Department has indicated that 7 substantive responses were received, with all welcoming the overall proposal to outline the arrangements and the protocols whereby mediation could be funded by legal aid in non-family civil cases, and the promotion of mediation within the justice system. The responses and a number of the respondents criticised the remuneration rates as being too low, and there was general support for the accreditation of mediators, though it was suggested a number of other bodies should be added to the list, and the majority of the respondents disagreed with the proposal that legal representatives should not be present during the mediation process except under prior authority. The Department intends to make some changes to the proposals as a result of the consultation. These include allowing a solo solicitor for the legally aided party to attend mediation, setting a flat rate of £80 per hour rather than a variable rate, which is in line with the rates charged by the Law Society and Mediation NI, allowing reasonable mileage and parking expenses for mediators, and providing legal aid contribution to the cost of a venue for mediation. The Department also advises that the list of accredited mediators is flexible and may be added to if certain conditions are met. The cost of the business case has been reduced from $45,000 to $26,000 based on a predicated lower rate of persons availing of mediation, which may be offset by savings to the legal aid fund from the cost of the protracted negotiations. The Department intends to issue a general authority to the agency which advises the legal profession of the arrangements for mediation in October, and subject to any views that the committee might have. And so it's to really just seek the views of the members on whether they are content to note the results of the consultation, the changes being made to the original proposal, and the intention of the Department to issue a general authority on the protocols and the arrangements for legal aid for mediation in non-family civil cases, or whether they wish to submit any views or comments or require any further information or clarification. Any comment? I think in fairness, they have listened to some of the concerns and they have endeavoured to try and meet some of the issues that were raised. So there's been some progress. Okay, thank you for that. Item 13, the Troubles Permanent Disabled Pension Scheme. And the information in regards to this is pages 547 to 602 of today's pack. At the meeting of the 8th of July, the members agreed to request a response from the Department of Justice to the issues and concerns raised by the victims' representatives groups during the informal meeting on the 7th of July, and to invite the departmental officials and representatives of Capita to attend a committee meeting in early October to discuss the scheme. The Department's response sets out the position on each of the issues and highlights that while it has ongoing responsibility for the administrative aspects of the scheme when it becomes operational, as it now is the case as of the 1st of September, the delivery of the scheme falls within the responsibility of the Victims Payment Board, which is sponsored by the Executive Office. The Department has also confirmed that Justice officials are available to attend the committee meeting on the 7th of October, and has suggested that as there may be issues that would fall more appropriately to the Executive Office, that Gareth Johnston, Director of Victims and Survivors Division in the Executive Office, should also be invited to attend. Capita officials will also attend the meeting on the 7th of October. The committee has previously written to the First Minister and Deputy First Minister requesting clarification on the Executive position in relation to the funding of the scheme payments, and the response outlines that £19 million was secured through the June monitoring round process for payments in 2021-2022. The Executive is of the view that adequate funding for the duration of the scheme should come from Westminster, and the Minister of Finance is leading on the engagement on the matter of overall funding of the scheme. The Department of Finance is therefore taking forward the dispute resolution process with the Treasury and the Northern Ireland Office. The Committee of Finance has provided a copy of the strategic outline case for the scheme and further information on the scheme administration costs. Just to ask the members then to note the information provided by the Department of Justice, the First Minister, Deputy First Minister and the Committee for Finance, unless there is any further clarification, and also to seek your agreement to send a copy of the responses from the Department of Justice to the victims' representatives groups that we had met. And can I just thank those members who engaged with us in those discussions. It was very much appreciated. And also to seek your agreement to invite Gareth Johnston from the Executive Office to attend the oral evidence session of the Department of Justice officials on the 7th of October, and whether or not the committee should request any formal meeting with the Chair and members of the Victims Payment Board to discuss the monitoring of the scheme possibility in conjunction with the Committee for the Executive Office. That raises for us a bit of an issue that we need to be careful. And I'm not I'm going to try and be cynical on this, but it may be how it has worked out, that the operation now of this moves over to the Executive Office and is now not, in a sense, the responsibility of the Department of Justice. So I think that because we have taken considerable degree of interest in ensuring that we would monitor, and we gave commitments to the victims' representatives that we met, that we would do this, but we need to be clear of the lines of distinction between what we can do and how we tread into the area of the Committee for the Executive Office. So are you happy, are you content with what I've outlined in terms of that when we bring capita and we bring officials, we also will bring the fella Gareth Johnston from the Executive Office, and then I think we'll try and ensure that may require me to, on your behalf, write to the Chair of the Executive Office Committee, just so that we are all heading in the same direction in regards to the way that we have said to victims' organisations we will monitor the process of the rollout of this particular scheme. Are we content with that as a way forward? Okay. Any comments, questions? Because I know this is an issue that you'll have received correspondence from. I know that there's organisations that have been inundated with requests, and certainly there's a lot of activity out there. We will give it until we will have a presentation on the 7th of October, and by that time we should have a sense of some of the numbers and maybe some of the specifics, and there's one or two issues that are starting maybe to appear, but I think we need to give it that wee bit more time. Content? Yeah. Sinead?
Yeah, thanks, Chair. No, I agree. I think we do need to manage the expectations of what exactly this committee is charged with the monitoring of, and the fact that the infrastructure in terms of the application and payment is via the department. We should keep our focus there and perhaps ensure that the victims groups do understand that that's the piece that we can speak directly to Justice about and that they are accountable for. But there is that crossover with the Executive Office that isn't helpful, to be honest. It would have been neater if it all had sat in one place, but those parameters were outside our control. But I do think we do need to closely monitor that the infrastructure and the pace that the Minister did take on in building the payment model is working. And that's why I think maybe as a committee our focus needs to be almost driven by the end user, because they are the people who will tell us whether that system is working or not. They'll be the first to alert us, and in which case we then go back into the department to explore. Hopefully we won't have to, but if there is any breakdown in how the system's functioning. But I'm really conscious that the parameters are a little bit unclear to the public eye, and appreciate that. Thank you, Chair.
Yep, and I do think that we have a duty to ensure that we try and demystify any of that, because what we don't want is a situation where you have this ping pong between the Department of Justice and the Executive Office as to who is or who is not responsible. And clearly I get the sense that what Justice are saying, they're responsible for bringing the scheme to its birth, but as of the 1st of September of this year, it is now the responsibility of the Executive Office in terms of how that is rolled out. There is one other issue that I think that we should raise with the Department, and it has come up with a number of organisations over the summer, given the fact that many of them, and there are some appointments that have been made of advisors, and they have been funded, but just so that we can ask the Department of Justice what additional resource is going to be made available to victims' organisations to be able to cope with the huge additional request and work that has now been placed on them as a result of the launch of the scheme. And I think it'd be interesting to see what the department would say in regards to that. Agreed?
Agreed. And Chair, if I might just add to that, it has been played out in the public domain that some victims have made it known that they have been notified of quite large fees that would be payable for application, and that shouldn't be happening. And I think we need to find out within the department, is that widespread? If it's happening, does our committee have a role to play in communicating with victims or applicants that they shouldn't be paying those hefty fees, that services are in place, and acting as a point in services to where exactly those services are?
Okay. And if you're happy, Sinead, we'll include that in the correspondence to the department along with the issue of additional finance for the organisations. Okay?
Thank you, Chair.
Thank you. Okay. Are you happy that we request an informal meeting with the Chair and the members of the Victims Payment Board? Because they will become critical to this. And we'll try and put something together. And so you're happy? Okay, thank you. Item 14 is correspondence. And thank you for your indulgence. We are coming to a conclusion, even though when I see on this it says we're at page 600 and we still 1,000 pages. I nearly fainted whenever I saw that. And my heart went out to the officials who had to put all that together. But anyway, we'll proceed. There are 34 items of correspondence, and this meeting has more, given the fact that we had meetings over the summer. So this hopefully will not be as intense over the next couple of months. So there are 34 items of correspondence. They're at pages 608 to 1086 of the pack, as well as a list of annual reports and accounts, which are at pages 616 and 17, which were previously circulated to members at the end of July. Any member wishing to obtain a further copy of any of these reports should contact the committee office, and they'll be happy to oblige. Just want to draw your attention to 6 of the items in the meeting pack, and then if members have any comment to make in relation to any other, then we'll deal with those. Item 14.6 at pages 807 to 829 of the meeting pack is a letter from the Department of Justice providing a copy of the 2020-21 annual report of the Independent Reviewer of Criminal Record Information. The report contains 2 recommendations from the previous reports which have yet to be fully implemented. And can I get the agreement of the members to request the timescale for the implementation of the 2 recommendations from the Department of Justice? Agreed? Item 14.12 at pages 877 to 878 is a letter from the Department of Justice advising of a data breach on the 21st of July 2021 by Gun Trader UK, an online firearms trading site affecting its customers, including 803 customers in Northern Ireland. The data breach has been reported to the Information Commissioner's Office, and the PSNI Firearms and Explosive Branch is supporting an investigation being led by a national crime agency. Just to ask for your agreement on whether an update on the data breach investigation should be requested from the PSNI. Agreed? Thank you. Item 14.21 at pages 916 to 925 is a letter from the Director of Public Prosecution providing further information on a range of issues that were discussed when he attended the committee on the meeting of the 17th of June. The Director has also indicated that he is open to appearing in front of the committee twice a year to provide members with an opportunity to ask questions and receive updates on prosecutorial matters. To maximise the benefits of these sessions, he suggested one session could focus on the prosecution policy, practice and procedure, and the other could be more in regards to performance. Focused and could be informed by the publication of the PPS Annual Statistical Bulletin, which is usually available in late June. So are members content with the Director's proposal to appear in front of the committee twice a year as suggested in the framework for the sessions? Agreed? I have to say it is welcome, and that the PPS, the Director, has taken this approach, and I think it is a good step, and it will now be incorporated into the timetable for the work programme for the committee. Item 1425 is at pages 1013 to 1016. It's a response from CJINI setting out the views of the Chief Inspector on the Department of Justice Action Plan to address the recommendations in the CJINI Report on child sexual exploitation in Northern Ireland, and providing further information regarding whether there is a need for a specific child sexual exploitation offence. And so I just seek members' approval to send the response to the Department of Justice and ask it to take account of the CJINI's views when bringing forward its action plan. Agreed? And then we have item 1434 at pages 1075 to 1077. It's a proposal from the Northern Ireland Judicial Appointments Commission to hold a briefing and discussion event that had been cancelled in May 2020 due to COVID on Thursday the 2nd of December from 12 noon to 2 p.m. Just to advise members that the committee is due to meet at 2 p.m. on that day. Therefore, if they are content with the date, the options are either to ask for the event to run from 11 to 1 or to put a start time in the committee meeting back until 3 p.m. What is your preference? Is it possible that we go for the 11 to 1? Or, Gemma, would it be more suitable if we put the back to 3 for you?
Maybe 3.
Right. We're agreed to go, just put our committee back to 3. Agreed? Okay.
Agreed, yeah.
Okay, thank you. Sinead, I'm just checking, your hand's still up, but maybe is that from a previous... Oh.
Apologies.
Okay, no, that's okay. And now Rachel's hand's up, that's okay. Rachel?
Chair, I just want to make a couple of comments just on a couple of items of correspondence. The 14.2, which is obviously a disappointing delay to the operational date for the domestic abuse offence until next year. I appreciate the Minister has outlined the reasons why. I'm just wondering if we would be able to seek regular updates from the Minister and the Department on a date on that. I know that has caused quite considerable distress over the summer to a lot of organisations and victims groups as well, just on that offence not coming in as expected. But I do appreciate that it is a massive piece of change of legislation and also rolling it out. And that would be sort of then a similar update as well on terms of 14 point, and I've just lost it, apologies. The Executive Office response on the Violence Against Women and Girls strategy. I know this is something that we all had spoken very passionately about in the Chamber, and there was a motion brought as well. And this update is the 25th of August, but I would love to know if there's an intention of having a Violence Against Women and Girls strategy out for consultation in this mandate. So just two things there if we could ask for an updates on. Okay, agreed. Thank you. Agreed. Okay, and the final one that I have, unless if there's any other member has any others, is in reference to 1435, and that's a request from Family Mediation Northern Ireland to present its briefing paper on the significant and lasting impact on children and young people of poorly managed family breakdown when parents separate, and the need to increase the use of family mediation services in Northern Ireland to the committee sometime in the autumn. Agreed? Okay. So if members are content then to agree the actions, the remaining items of the correspondence is set out in the cover sheet, or if there's any other comments. You all content?
Content.
Okay. Thank you. That brings me then to just a couple of items. Item 15, which is the Chairman's business, which will be brief. Sinead and I have received invitations to attend the Law Society Council dinner on the 24th of September. In our capacities as chair and deputy chairs, and it's just to inform members that that is the case. If that date doesn't suit either of us, then we may come back to some members of the committee to attend in our place. So we'll try and get that clarified as soon as we possibly can. Then finally, if there's any other business and any member wishes to raise? No? And if that's the case, can then I just advise that the next meeting of the Justice Committee will take place on Thursday, the 16th of September 2021 at 2 p.m. in the Senate Chamber. And can I really thank you for your indulgence and your help to get through what was a mammoth agenda, but I really do appreciate the time that you gave today, and wish you well for the remainder of the evening. Thank you very much.
Thank you very much.
This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound.